Good morning, everybody. It's Tuesday. We're trying real hard here not to make it into a Monday. Welcome to the Courtroom Files Live. A lot of things broken out in the world today, so we're a few minutes late. Apologies. We are not on X today because X is unable to stream at the moment. The chat on screen was broken but came live at the last moment. Cloudflare has issues today, and it's affecting everything. But we push forward as best we can. Let's start in Miami-Dade with Mindy Glazer, where undoubtedly people are having a lot more of a troublesome day than I am.
Said in snatching, criminal mischief, a first-degree misdemeanor, and battery. Your attorney is here. Good morning, counsel. You want to state your name for the record?
Yes, good morning, Your Honor. Andre Rouvier on behalf of Mr. Guerrero. It's nice to see you, Your Honor.
It's always a pleasure. Mr. Rouvier, I always call the private lawyers after the in-state calendar, okay? And I don't promote lawyers till after we finish the calendar.
That Judge, fine. I just wanted to get my name on the list. That's all I was trying to do.
I always call them in the order I see on Zoom unless you come into court. But anyway, you're here now, and I know you've had a chance to review the arrest affidavit. Do you have any argument regarding probable cause?
Judge, I don't. I just want the court to know that this is a individual. He's a county inspector, has been for 10 years. And this is an isolated, apparently stemming from a ongoing divorce and games with the children. So with that, Judge, I would ask that he be released on pretrial release.
All right. So it looks like he's going to have to go to family court to discuss the custody.
That should be fine. Sir, there's probable cause for robbery by sudden snatching for grabbing the victim's phone. He threw the phone. There's no value for damages. It only says the value of the phone. So it'll be a second-degree misdemeanor on count 2. And count 3, there's probable cause for the battery. So, sir, I'm entering a stay-away order from the alleged victim, Jennifer Toledo. No contact with her, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means, and you must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you have to go to the victim's home to collect any personal belongings, sir?
She has moved out to her parents' house.
She what?
She has moved out to her parents'
Okay, so that's not an issue. Very well, then. Do you understand the stay-away order? If you have any questions about it, you can ask your lawyer. So that's fine with pretrial. I'll order him in. Pretrial services, alternate bond, count 1. Robbery by sudden snatching is $2,500. Count 2, criminal mischief is $150. And count 3, battery is $1,000. All right, sir, you have a good lawyer. Listen to what he tells you. Thank you, Mr. Rouvier. Good day.
Thank you, Judge. Nice seeing you.
It's a pleasure. Thank you. Mr. Heller, are you ready?
Judge, I just received it now. I'm just reading it. If you give me another few minutes, is that okay?
A few minutes, no worries. Moses, DeLeon, Spanier, page 9.
Corrections, this is added.
Corrections.
This is number 27 on page 9.
Corrections, it's an added charge or no? I don't know. Sir, good morning. Do you speak English?
Yes, ma'am.
Thank you. You were arrested for a case from October 29th. The charge is false imprisonment with a deadly weapon, aggravated assault with a firearm, domestic battery by strangulation, and battery. I will appoint the public defender's office for you. So there's probable cause for, I see count 3 and 4.
Add a charge.
Probable cause for everything. So, sir, you are ordered to stay away from the alleged victim, Lazaret Morales. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order?
Yes, ma'am.
All right, thank you. State what you're asking for. This is
Standard bond.
pretty violent.
Right, he's corrections, he's no bond on the other case.
The other case, he has a bond of 18,501.
With, okay. If you want to do a bond with house arrest on this case,
Who gave the bond on the other case? The division judge? Or maybe it was a true armed burglary. I don't know. That's fine. False imprisonment with the weapon. Will be $2,500. Because I'm adding house arrest. I'm not going to do a higher bond. Count one is $2,500. Count two, aggravated assault with a firearm is $5,000. Count three, domestic battery by strangulation is $4,000. Count four, battery is $1,000. That's plus house arrest with a GPS monitor. That will be level three house arrest with a curfew, 11 p.m. to 6 a.m. Stay away from the victim, sir. Have a nice day.
Judge, I've read the arrest form whenever you're ready.
Thank you. Okay. What did I do with it? This one? How to move it? Let's recall Noah Alush on page 5. All right, so good morning, sir. You were arrested for aggravated assault on a law enforcement officer, fleeing and eluding a police officer, resisting an officer without violence, and failure to obey a law enforcement officer. Your attorney is here, Mr. Heller. Good morning, Mr. Heller.
Good morning, Your Honor. Peter Heller on behalf of Mr. Alush.
Can I have a calendar, please? The reckless driving, that's a citation, so I don't believe that's what.
There's a rec.
So, Officer Blanco, you've already been sworn in. Is there anything you wanted to say?
Yes, Your Honor. I'm the victim officer in this case. Yesterday at about 5 p.m., the defendant was operating an electric motorized scooter on the beach walk at speeds of about 30 miles an hour. I attempted to stop him. He accelerated to avoid me, striking me, knocking me to the ground and injuring my right elbow. When I was on the ground, I looked at him. He saw me, and instead of rendering aid, he decided to jump back on and flee. He led officers on a chase throughout the city. We were finally able to apprehend him. Your Honor, I'm asking for an elevated bond. He's a resident of California. He has a California driver's license. Clearly, he will flee from law enforcement. And I believe that without an elevated bond, he's going to be a flight risk and come back to court.
Okay. State, do you have any questions for Officer Blanco?
no questions.
Mr. Heller, any arguments or, I'm sorry, do you have any questions for Officer
I just
Blanco?
have a quick, you say he's a resident of California. You have his permanent address is listed in Miami, though.
Your Honor, I researched the records. He has no Florida driver's license. His only ID is from the state of California.
Okay, so the address of 5750 Southwest 56th Street, do you know how that was ascertained? In Miami?
I'm not the arresting officer, so I don't know, but I could not
Okay.
find a local address for him.
All right, and your assertion is that he intentionally drove towards you with one of these scooters that you stand on? Is that what it is?
Electric motorized scooter. It's not street legal.
Okay, I understand that, but is that the ones, when I'm thinking of scooter, is that one that you stand on? Is that what you're talking about?
Yes.
Okay, and how fast do those go?
Well, the legal ones are maxed out at 20, some at 28. The illegal ones, the off-road use only, which is the one your client had, is made to go 60 miles an hour.
60 miles an hour?
Correct. They're not street legal. Those are
Wow.
only for abuse.
Okay. Now, I have no further questions for the officer, Judge.
Video, are you there to put the camera on the victim? You can see his arms bandaged up.
No, I'm not disputing, what he said at this point.
Let me finish reading.
I just don't know if there was intent. That.
Well, you're
remains
not
to be
allowed to
seen.
ride an electric scooter or anything motorized on the beach walk, which is probably why he was there and doing enforcement.
Yeah. My guess is he probably got scared. I don't know, but I can't imagine that he was going to run directly at him to try and hit the officer with a scooter. It doesn't make much sense, but I'm not going to dispute what the officer felt. It's his,
He went on
his reasonable, excuse me.
evading several other officers with lights and sirens, evading them. The only reason why we caught him because he hit a dead end over on Biscayne Point. But he had no intention of stopping.
Okay, well, what his intention is that it's to be determined. But I'm not arguing with you,
Just
sir.
give me a second to read the arrest affidavit. What did?
Yes, please. And I don't believe he has any priors. Is that correct, State?
Oh, okay.
So some sort of domestic arrest in 2013 that I don't have a disposition on. It looks like Missouri. That's the only thing that came up. Also, I put in his area code on his phone. It looks like that could be Ohio. I don't know what he's doing in South Florida.
Your Honor, that's also to my point. His Instagram, where he posts all these videos, is called Nomadic Noah. Nomadic meaning moves around all the time.
Judge, I was contacted by his boss, said he's working here locally. I don't know what he does.
So he had to be tased to be stopped. Okay. And just, officer, what are your injuries? Because he's charged with aggravated fleeing and eluding a police officer. It should be after accident or injury. But what is your?
I have a hairline fracture on my elbow, and I have to undergo further treatment and see what tissue damage I have. So I have a follow up next week.
Certainly wish the officer well.
Thank you, Counselor.
So, count one, I don't know what bond you're seeking, but officer's asking for an increased bond. He may be a flight risk.
I don't believe he's a flight risk, but if he doesn't have any significant priors, Judge, I would just ask, because he does work here. I can ask him what he does. I don't know. I just spoke to the representative for the boss.
Your Honor, and my legal counsel, I'm a graduate student at the University of Miami. That's
Okay.
So count one's aggravated assault. It should be on an officer, an aggravated battery if he has a hairline fracture in his elbow.
Yeah.
Am I able to speak at all?
Yes, sir, you're presumed not guilty. Mr. Heller's a very good lawyer. You should listen to what he tells you and you'll speak to him privately. I'm just finding probable cause for whatever's on the arrest affidavit or based on the testimony presented. So count one is probable cause for aggravated battery.
We just asked for standard bond, Your Honor.
That's $15,000 bond.
Is that
The first degree felony. I
right?
believe.
It bumps it up, right?
He's lucky he's not being held. No bond on that. Count two, fleeing and eluding a police officer. There's probable cause for that charge after accident or injury. That bond will be $5,000. And count three, there's probable cause for resisting an officer without violence, $500 bond. Well, 3 and 4 are similar. 3 is resisting without, that's 200. I'll split those. Well, what's the bond on count 4? Correction?
Count 4 is the traffic. He'll be going to jail.
Oh, so that's not even before me. So count 3 will be $500. So the failure to obey a law enforcement officer and the ticket for reckless driving will be heard now in court with 5-3 before the county court judge. If you want to go there, Mr. Heller, that's going to be next. All right. So the total bond here is $20,500. All right.
Thank you, Judge.
Sir, I hope you feel better.
Thank you.
It's a Tuesday. It's the Courtroom Files Live, and it is weird day. I know some of you are having issues out there with the feed. Everything good. Everything's going out right. But, yeah, it's stuff is broken today. So we're going to soldier on, do the best that we can, because that is all we can do, and I am committed to providing you with the best courtroom content possible, even if our internet and corporate overlords try to interfere. Let's stay in Florida. Let's go say good morning to Judge Mercer.
Barfoot, come on up, please, so that Mr. Axon can see you and you can see and hear him. Ms. Barfoot, you're here for first appearance, ma'am, for a charge of violation of injunction for protection. Ms. Barfoot, there is probable cause in the complaint. Ms. Barfoot, Mr. Axon is here on your behalf. And I know the attorneys have reached a tentative plea agreement, and I expressed to Mr. Mitchell, asked that he expressed to Mr. Axon. I'm not 100% sure that I want to do that today because I don't know that the state has interviewed the alleged victim or had a chance to talk with law enforcement. But let me start with the state, Mr. Mitchell, and we'll hear from Mr. Axon, Ms. Barfoot, and we'll see if anybody has any questions. Mr. Mitchell.
Yes, Your Honor. I'll elaborate. It was Wes Atkinson that I was talking to and that we had reached an agreement on. Curry's just covering for him today, but yes, there is still a tentative probation agreement with the potential of dismissing this new case right here. And I understand that court's not interested in taking that plea today because we need time to speak to the victim, review the video, make sure law enforcement understands and is on board with that. So based on those factors, we would say we would move to revoke her bond today, but see if we could possibly get her back up after a few days after we've reviewed the evidence.
So let me ask a question. The complaint says there's a long history of alleged harassment. That's what the complaint says. And I signed the warrant a couple of days ago. Has law enforcement, has state attorney's office had an opportunity to talk to law enforcement to get their input on the possible agreement that you and Mr. Wes Atkinson have reached?
Law enforcement, no.
Okay. What about the alleged victim? Have y'all spoken to the alleged victim since this most recent incident about her input?
Since this most recent one, no, but we had been in discussion about the previous one.
So, Mr. Curry Axon, I don't know that I was texted a tentative agreement this morning, and I don't know that I have a problem with that, but it seems to be like it might be kind of rushed to me. I'm going to listen to your input, obviously, Mr. Axon, and see what your position is. What are your thoughts, sir?
Judge, and Wes Atkinson did tell me what the plea agreement was, obviously. Judge, and I'm going to be honest with you, Judge, and I'm not trying to offend nobody. I'm not sure that they're neighbors, and I'm not trying to get into the facts. And I do my preference, if she was not in jail, and I know that the court may revoke her bond, would be to allow us to file a motion to dismiss or something, because the law as it relates to this type of thing when they're neighbors, I'm talking about fence neighbors, is a little bit more, I think a little bit more specific, and you have to really get to the point where, it's intentional and it looks intentional. And I'm not saying the court has already found probable cause, and it may be. I'm just saying that my position is if Ms. Barfield would want to take the plea, that's certainly her prerogative. I know she's in jail and probably wants to get out of jail. But, I would like the opportunity to, to explore whether or not this is in fact a violation of the injunction. And we have talked to Ms. Barfield about this in our office. And, with the old charge, we obviously have not been involved with the new charge. So I would just leave it up to her. If she wants to accept the plea, that's fine. I'm just concerned whether or not this is in fact a violation of injunction based on my understanding of the case law related to this type of thing.
So thank you, Mr. Axon. So here's what I typically do with a violation of a bond is if it's a strong case, I'll go ahead and revoke their bond. However, if it's a marginal case, the new charge is a marginal case, it's very common for me to just give the state and defense time to look into it. And I may hold them without bond temporarily, but not actually revoke the bond. And the complaint I would put in that second category, Mr. Axon. There's allegations of the allegations are she allegedly walked in front of camera that the alleged victim was recording, and basically made a comment about, I know you're recording me, but I don't care. I'm not doing anything wrong. if those statements were directed at the alleged victim, then that may be a violation of an injunction, but it's not the type I would revoke her bond for without more information. So here's what I'm going to do. I'm going to set a bond in the new case. I'm going to set the bond at the same bond you were set previously, which actually it wouldn't be the same bond. I think previously it was a $250 cash bond. It's going to be a $500 cash bond this time, but I'm going to hold you, Ms. Barfoot, at least for a day or two, because I want Mr. Mitchell and Mr. Axon to have a chance to look at the video. And then if the state says there's not enough for them to go forward, then we're going to get you out of there as soon as we can, and we'll deal with the other case later. If the state, the alleged victim, the defense, and law enforcement are on the same page on this probation offer, I'm fine with that. My preference, though, is to do that once everybody's had a chance to talk about it, not do it at first appearance on the several hours after her arrest. So the question is, Mr. Mitchell and Mr. Axon, I know Ms. Barfoot wants to get out of there. I'll be here tomorrow. Today's Tuesday. I'll be here Thursday. I'll be here Wednesday, Thursday, and Friday. So Ms. Barfoot, what I think is going to happen, ma'am, is I'm going to see you the next day or two, possibly tomorrow, possibly Thursday, possibly Friday. And if once your attorney and Mr. Mitchell and has a chance to look at the video, then Mr. Axon may come back and say, Judge, now that I've looked at the video, there's more to this. I'm asking for something different. Or they may come back and say, Judge, we've talked to all the parties involved and we want to do the probation. So I'd love to do it tomorrow if y'all have time to get the video and watch it by then, Mr. Mitchell.
That's what I was going to say. Like, I was going to request if we could tentatively make it a 7-day hold like we normally do. But if we get it before then, I have no idea how long it'll take for them to get us the video. But if we get it before then, I can let Mr. Axon know, and I can say that I've reviewed it, and then we can bring her up before the end of the 7-day hold.
Okay. So let me do this. Law enforcement in the warrant process sent me a lengthy video because I had some questions. They directed me to watch just a few minutes of video by email. Not even a few minutes. Literally they directed my attention to a 10-second portion of the video. I watched that 10-second portion of the video. After first appearance, I'll forward that email to both of you. And Mr. Axon, it was a marginal call, but there may be something else in that lengthy video that either helps or hurts your client. I have no idea.
Yes, sir.
But that way y'all will have at least what I was sent. Now, is there another video besides that one? I have no idea. Is there another fragment of that video that they want to draw your attention to? I have no idea. So, Ms. Barfoot, I'm going to do a 7-day hold, which is pretty normal for VOP that I don't revoke the bond for, excuse me, a VOB that I don't revoke the bond. Ms. Barfoot, I know Mr. Axon's office well, Mr. Mitchell's office. If they can watch that video today, it's very possible I will see you tomorrow. If not tomorrow, Thursday. So, Mr. Axon and Mr. Mitchell, I'm not saying I wouldn't accept that offer. I'm just saying I really would like for y'all to talk to the people involved because I don't want this to, we need to fix the problem. Whatever the problem is, we need to fix it. Mr. Axon, any input or suggestions on that?
No, sir, Judge. I think that's a good resolution at this time. Ms. Barfoot, can I speak to Ms. Barfoot? Ms. Barfoot?
Absolutely.
Ma'am, listen, I think that's a good way to handle this. Okay. If we can get the video and look at it, I mean, we're going to do our best to get you back in tomorrow. Okay. But I think that's a good way to handle this. Okay. And I also want you to know that they moved the injunction hearing over to November 27th. Okay? So we'll be back in front of Judge Garcia after that. Okay. So let's just do it this way. I think this is a good way to handle it. Okay. And we'll try to get over there this evening to talk to you. Okay.
Thank you.
You're welcome.
I'm worried about my mother.
I understand.
Well, ma'am, I very well may see you tomorrow. Knowing Mr. Axon's office, I fully expect to see you tomorrow or Thursday because they stay on top of their cases very well. Mr. Mitchell, any other input?
No, Your Honor. We'll take a look at the video today.
Okay. I'm going to try right now while we're here to put my hands on that video and go ahead and forward it to y'all. Was it video or was it text? They emailed or texted it to me. So I don't know if it was email or text, frankly. I can't remember. I know they have some technical issues. It's a small agency, and they had some technical issues getting it to me. So after first appearance, I'll get that video to y'all before 9:15 this morning. You both will have it. So, ma'am, Ms. Barfoot, I'll see you in the next few days, possibly even tomorrow morning. Okay, ma'am?
Right.
Thank you.
Thank you, Your Honor.
Thank you. Thank you, Mr. Axon.
Thank you. All right.
All right, so after Ms. Barfoot, we have one person that has friends or family here, and that is Arthur Hayes.
Hey, how you doing, sir?
Okay. Anything else you want to say? Okay. Mr. Hayes, one of the alleged victims is in the courtroom. She doesn't want to speak, but she does want to say she feels like a drug treatment program would be helpful, and that's Miss Lee. Miss Lee is in the courtroom, and that's her input this morning. So, Mr. Hayes, you're here because you've been accused of 3 charges. You've been accused of 2 counts of burglary with assault or battery, and 1 count of resisting an officer without violence. Mr. Hayes, there is probable cause for those 3 charges. I read the complaint. I'm also familiar with your criminal history. I took a look at your criminal history this morning, and you've heard Miss Lee's input. Mr.
I haven't heard.
Her input just then was that she thinks you need inpatient drug treatment. Is that right? That's her input, is that she thinks you need drug treatment. Mr. McDaniel, anything else on behalf of Mr. Hayes?
No, Your Honor. I mean, there may be some other disabilities also, but I don't have anything additional.
Thank you. Mr. Mitchell, anything?
Your Honor, I was just reviewing the complaint to see if there was an allegation of drug use. I couldn't find any, and I would have requested random UAs, but based on this, we just request a reasonable bond under the circumstances.
Okay. Mr. Hayes, the problem is that your 2 of those charges are first-degree felonies that may be first-degree punishable by life. They're very serious charges. The burglary with assault or batteries are very serious. That means you're going to get a higher bond because they're higher degree crimes. Mr. Hayes, based upon your history and the charges, if you want to ask a question, I'd be glad to answer it if I can, Mr. Hayes, but please don't talk about what you've been accused of. We are being recorded. I don't want you to say something to hurt yourself. You have a question?
I'm not.
You want to talk
Not at all, sir.
You keep trying to say something while I'm speaking. Do you have something you want to say, Mr. Hayes?
I'll let you finish.
Okay. Mr. Hayes, I'm going to set your bond at $50,000 on those first-degree felonies, $2,500 on the misdemeanor. Your total bond is $102,500. You have a condition, no contact with either alleged victim. No contact with Miss Lee, no contact with the other male individual that was allegedly a victim in this case. Mr. Hayes, you will get to use the phone in a few minutes, sir, to try to post the bond. We're also going to give you a notice for your next court date, which will be
I think this one's still the 2nd.
December 2nd at 8:30 a.m. will be your court date, Mr. Hayes. So you'll get to use the phone in a few minutes to try to post the bond, Mr. Hayes. As far as drug treatment on that kind of charge with that kind of seriousness, I would want the state to talk to the other alleged victim. We know Miss Lee's feelings. I'd like for the state to talk to the other alleged victim and have a chance to before even consider any kind of release to inpatient drug treatment. If Mr. Hayes is interested in that, and I have no idea if he is or not. Mr. Hayes, do you have any questions?
I got a lot of questions.
Any questions you want to ask me, sir?
Listen, sir, I don't understand how I got burglary with an assault when over the radio, no one got burglarized. I had permission to come over there. That Sunday night, I was questioned about her phone. Now, I was coming to get her and give her her phone.
Nothing else, Your Honor.
All right, Mr. Hayes, wish you the best. Thank you for coming, man. That's it for friends or family in the courtroom. So we'll go back to the top of the docket, which is William Melvin. Mr. Melvin, come on up, please. Mr. Melvin, good morning. You're here because you've been accused of, well, first of all, you have an out-of-county warrant out of Bay County. It looks like that's a violation of probation warrant with no bond. In Jackson County, you've been accused of 3 charges: possession of drug paraphernalia, obstruction by disguise, and possession of methamphetamine. Mr. Melvin, I sent a text to the 2 attorneys this morning, asking them to take a closer look at the obstruction by disguise. I don't know that the allegations fit that charge, but I wanted the attorneys to be aware of my concern. Mr. Mitchell, any input on that charge?
Your Honor, I read the complaint. It seems more like an obstruction of law enforcement or something along those lines. The words are escaping me, but I don't think it's obstruction by disguise. He just refused to identify himself.
You agree, Mr. McDaniel?
Correct. It's not an obstruction by disguise.
So, Mr. Melvin, obstruction by disguise is where you give the wrong name to the officer intentionally. You're accused of refusing to answer a question. That's not the right statute for that allegation. So there's no probable cause for that charge. I'm not saying there isn't a charge that fits. I'm saying that charge doesn't seem to fit, and the state and defense agree. So I'm going to find no probable cause on that charge. There is probable cause on the other two charges. I'm going to set you the normal bond that I normally would set for those two charges. The methamphetamine bond would be $5,000 cash or surety. Paraphernalia bond would be $2,500 cash or surety. It's an ROR on the obstruction by disguise for no probable cause. Your total bond is $7,500 cash or surety. You have a condition of random urinalysis on that bond, and be aware of the Bay County hold. If you do post bond, you'll deal with Bay County. As far as your court date in Jackson County, just a second. As far as your court date in Jackson County, that would be December 2nd at 8:30. It'll be your court date in Jackson County. Any questions?
Yes, sir. Without that first one, how'd they get to find the meth on me and the paraphernalia?
That's stuff that motion.
Yeah, they had the right to investigate when you give them the right name. I just don't think they charge you with the right charge. I think they're going to correct it possibly and charge you with resisting an officer without violence or obstruction of justice, which probably should have been the correct statute.
All right, thank you.
Yeah, wish you the best, sir.
And Your Honor, I'll get in contact with the deputy to send in an amended complaint for the proper charge.
Thank you. Christopher Cooper is next. Mr. Cooper, good morning. Mr. Cooper, you're here for two issues. You have an out-of-county warrant out of Calhoun County. That's case 20-36 CT. That Calhoun County case has a bond already on the warrant. That bond is $523 cash. That's what it looks like to me. I'll ask the jail to verify that after first appearance. In addition to that, in Jackson County, you have a charge of grand theft of motor vehicle. It's 20-315 CF. I read the complaint in that case. It looks like, according to the complaint, you told law enforcement allegedly that you were going through some drug issues and then had multiple grand thefts in multiple counties. And this, for whatever reason, you're just now getting back to Jackson County. But I think you're entitled to a bond on that case as far as I can tell. Let me see if the attorneys have any additional information before I address that bond. Mr. McDaniel, anything?
Just that he's never been out of jail. He's been, he just come from prison. Since all this has been going on, been in prison.
I kind of wondered that. Were you in prison in Alabama or where?
Georgia, I just got through doing 65 months, sir.
So you're going to get a bond in this case, and it's going to be a normal bond, most likely. I'm going to listen to Mr. Mitchell. But then you've got a small cash bond out of Calhoun County that's their case entirely. Let me see what Mr. Mitchell has anything to add. Mr. Mitchell?
Nothing at this time, Your Honor.
So, Mr. Cooper, I'm going to set you a normal $5,000 bond for this grand theft. It's cash or surety, no contact with the alleged victim. That means if you go through a bondsman.
Thank you, Your Honor. Good luck to you.
All right.
Thank you, sir.
5,000 cash or surety. Have a good day, sir. Yes, please give him a court date for December 2nd at 8:30 a.m. Sergeant.
Did we give a court date for William Melvin?
We did.
Okay.
We did. Yeah. Next case we have are two VOPs. Let me see Stephen Hockaday and Tamara Jennings, please. Mr. Hockaday and Ms. Jennings. All right, good morning. I'm seeing you at the same time because your cases are identical for my purposes this morning. You're accused of violating your probation. In both of your cases, the circuit judge has signed a no bond warrant. What I want to do this morning is get you arraigned. And the reason I want to do that is I want to get you a lawyer appointed if you're asking for one. In the violation of probation, Mr. Hockaday, would you like to have an attorney appointed to represent you?
Yes.
All right, Ms. Jennings, same question.
Yes, sir.
All right, I'm going to appoint the public defender's office to represent both of you. Listen to Mr. McDaniel. He's going to tell you your court date, and I'll see if you have any questions in just a moment.
Your Honor, we're going to plead not guilty. As to set this on the December 4th court docket, pretrial docket. I advise them both, Mr. Green, and speak with them. Ms. Jennings, I haven't had a chance to look at, but she told me it was financial only, and that she had paid most of the financial, I think, recently. So I'm just making the court aware of that. I have not had a chance to look at those. I don't.
Okay, so in Ms. Jennings' case, it does appear to be financial only. And it says the allegation is she's $2,091 in arrears. and let's see when she was put on probation. So the affidavit says that, well, sentencing date was 2020. So there is a no bond warrant. Now, normally when you see someone whose violation is based solely on financial issues, a lot of times the judge will set a bond or give an ROR or whatever on the case. But the judge looks at several factors. The judge will look at how long you're on probation, how much you have paid overall, and how much time you have left on supervision and those kind of factors. They also look at your income, if there's any information on that. So in this case, Ms. Jennings, right now you have no bond. That's what's on the warrant. That's what Judge Garcia has done. Now, will that change when you come to court? I have no idea. It's certainly possible, but it does appear to be a financial only allegation. And according to, as of August of 25, you are behind $2,091.68. In financial only violations, whatever you can come up with towards that amount, very well may help you when you come to court. So you'll get your phone in just a few minutes, ma'am, to contact friends or family for that purpose. Let me see if anybody has any questions. Mr. Hockaday, do you have any questions?
Yes, I do, Your Honor. I'm coming from Bay County. The charge that violated my probation, the battery on a Leo, was dropped to a misdemeanor. It was supposed to be a global plea offer for this county and Bay County because you share the same judicial district. So Thursday, my attorney came to see me and told me that I was signing time served and a year of probation, and that I would be getting out of jail Thursday or Friday. Come to find out on Saturday, they gave me initial appearance for Jackson County for the detainer that they had from February 4th, the date of my arrest.
So, Mr. Hockaday, here's the question. Here's the question for you. At the time you pled in Bay County, did you do it by writing or did you appear in front of a judge?
I did it by writing. He brought the paperwork to the jail and I signed.
Okay, so here's what the question, the question becomes then, does that written plea form, which I can pull it up if you don't remember, does that written plea form mention the Jackson County case at all?
I don't remember. I didn't have reading glasses. He just had me sign it. But when I brought
let's take a look at that and see, Mr. Hockaday. So give me a second to pull it up.
They told me it didn't have anything on global plea offer when I went to court on the initial appearance on Saturday.
Yeah, the only way you can do a global plea offer is if you have the agreement of the sentencing judge in the second county. So Judge Garcia would have had to been in the loop, and normally what that means is the attorneys in Jackson County would have to go before Judge Garcia and say, Judge Garcia, Mr. Hockaday's got a plea worked out in Bay County. We want to make sure that you're going to accept it. And if you do, then that's great. We'll go ahead and tell them that. That's very, very rare. Normally what happens is you resolve the first county and then you resolve the second one. But let's take a look at your plea form in Bay County, Mr. Hockaday. So give me a second to do that. I feel confident it didn't mention the Jackson County case at all, but if it did, that may justify some other release option this morning.
I mean, I have everything. Didn't bring any paperwork with me.
It was while I was under a Baker Act that all this happened.
What did you say about a Baker Act? What about a Baker Act?
This all happened while I was under a Baker Act from Jackson County being transported to life management is when all of this happened at the life management hospital at the time. I had been off my medication for quite some time, and I've never been to Panama City other than my suicide attempt. What?
It's either on the paperwork or it's not.
So there was this is confusing. There was a resisting without violence dismissed in Jackson County in January. But that's not the Bay County case he's talking about, I don't think.
I think the Bay County case is 25337 CF. Based on what it is Stephen Andrew Hockaday, correct?
Yes, sir, it is.
Yeah, it looks like it was a felony case that was amended down to a simple battery, and he was put on probation on Friday, I think.
I don't see a plea form in there. Do you see a plea form?
I'm looking at a benchmark, which is the Panama City or the Bay County one, and I do see a plea form right there.
You've got a plea form?
Yes.
I'm looking at CCIS. They don't have it in CCIS yet, I don't think. Okay, so I'm looking at the plea in absentia signed by the judge. and it doesn't mention the Jackson County case at all. So what that means is you're going to be held until you can see Judge Garcia, and then your attorney will bring up all this in front of Judge Garcia, but it's not referenced on your paperwork at all that Jackson County was part of the plea agreement. As I mentioned, that'd be very, very rare.
Okay.
It's possible, but it takes a lot of work for the attorney in the original county to do all that. So a lot of times they'll let the other county deal with it rather than try to get everybody on the same page. So right now you've got no bond. Any other questions, Mr. Hockaday?
I'm not going to be violated in Bay County now that I'm here, right?
So the Bay County charge, you were not on probation until the last couple of days, correct?
Right. Now I'm supposed to report in 48 hours.
No, you can't be violated. You cannot be violated for anything that is allegedly occurs before you're on probation, and you cannot be violated. You cannot be violated for not reporting if you're in custody because you don't have the ability to report. So the answer is no. Unless you commit a new crime in jail, you're not going to violate your probation by waiting on your court date. Okay.
Thank you, Your Honor.
Have a good day, sir.
Thank
Ms.
you.
Jennings, do you have any questions?
Yeah, you went. I mean, Judge, just that I think she's paid off everything and she turned herself in, I guess.
Yes. Your Honor, I can actually say something.
Okay, Mr. Mitchell has something to say in your case. He's the prosecutor, so listen to the attorney, ma'am, and then I'll be glad to listen to you.
So it does look like she has close to $2,000 in arrears, but the original restitution amount based on the disposition that I'm looking at was about $29,000. So it does show that she has made payments. So it's very likely this will be my case on December 4th, and I may be able to resolve it and help her out by then. I just wanted to let her know that.
Ms. Jennings, Mr. Mitchell is the felony VOP attorney too. So the same person will be handling your VOP from the state's perspective. Any questions, ma'am?
Yes, I have been in contact with the probation office down here. I did make that payment, so it should not be an arrearage of $2,091. It was paid, half of it was paid by the date they gave me, and then the other half was paid maybe 3 or 4 days later. Also, they did not come and get me. Like I said, I've been in contact, in communication, and I brought myself down here with my boyfriend and family members. So I did turn myself in because I was trying to get back home, to get to work, to continue paying. But I do understand y'all do have a process. I didn't bring any paperwork.
Just a second, ma'am. Give me just a second, okay? I'm gonna. The reason I'm interrupting is I'm gonna forget the questions I have. So where do you live?
South Carolina.
Okay, you came from South Carolina to get this case. Get a second. I'm asking specific questions because I'm trying to get more information that may help you. You came from South Carolina and turned your off, correct?
Yes, sir.
Okay. The next question is, by what method did you make these payments? Did you pay them by mail, through some internet system, or how?
Online.
And the last question is when? When did you make the payments? You said a couple of days apart, but you didn't tell me a date. Were they before or after the date I read to you in the affidavit, which was August of 25?
Okay, so half the payment was made by the date in August of 2025.
Okay, wait, we want to make sure we're talking about the same date. You can say the date they told you is what you said a moment ago.
Right.
I don't know if that's the same date. I don't know if that's the same date as the warrant or not. The warrant is August 29th. So my question is, when did you make the payments?
One payment was made on August 23rd.
Okay.
And then the other payment was made, I don't have the exact date, but maybe a week later.
Okay, so here's what I'm going to do. Given that information and given that it's financial only, I'm going to see you tomorrow. I don't want you sitting there 2 or 3 weeks. If the state looks into it and says, Judge, she paid it, she just paid a little late, we want to get her out. If they say that, I'd rather get you out tomorrow so you can get back to work. So I'm going to hold you until tomorrow. I'm going to ask Mr. McDaniel and Mr. Mitchell to take a closer look at the case, contact the probation officer, whatever they need to do. And obviously, I need Judge Garcia's permission or input. If you find out she's paid everything in full, Mr. Mitchell or Mr. McDaniel, I want to make sure Judge Garcia is okay with me letting her out tomorrow if that's verified. So, ma'am, I will see you at first appearance in the morning. Any other questions?
That's it.
All right,
Yes,
ma'am.
sir.
I'll see you in the morning, okay?
Thank you.
Yes, ma'am.
I'll talk to Judge Garcia.
And if she's paid it in full, I'll text Judge Garcia myself.
Okay.
But I need to know that before I text her.
Ms. Jackson is actually on the phone with probation right now as we speak. So
yeah, and
we're trying to find out.
Okay. Mr. McDaniel, I think the next case we have is David Bell. Mr. Bell, come on up, please.
Yes, sir.
Mr. Bell, good morning. Mr. Bell, you're accused of additional count of aggravated assault with a deadly weapon. So I got a text from the law enforcement officer that did this complaint this morning, and he said there was a typo in the date. The complaint says November 15th. He said it should have read November 14th. So just be aware of that. You're accused of this crime the day before the other charge that you're already in jail for. A different person you allegedly pulled a firearm on. That's what you're accused of, Mr. Bell. So don't comment. I just want you to understand they're accusing you of two different crimes, basically 2 days in a row. There is probable cause. I'm going to set you a bond. Let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mission.
He got the condition of no possession of firearms yesterday, didn't he?
Yes.
I guess we could request the same thing for this one.
Okay, so Mr. Bell, I'm going to set you the same bond I set yesterday. It's the exact same charge. $15,000 is the bond, cash or surety, no contact with this alleged victim, no firearms. That means your total bond from the 2 days, as far as I'm aware, the total bond from yesterday and today is $30,000 cash or surety. You're also going to have the same court date, which was December 2nd at 8:30. Mr. Bell, do you have any questions?
At that time, I can't ask for bond reduction, Your Honor.
You can ask,
told me.
you can ask for
Request
bond
point.
reduction anytime that you have a basis to do so. In other words, you need some basis. You need to have some reason that the first appearance judge was not aware of. That's a kind of a broad summary of it. So it's better to wait till your attorney's appointed so your attorney can do that for you. That's typically true to wait for the attorney to be appointed, but your criminal history and your mental health history are the factors that the judge is going to take into account, Mr. Bell, as well as the allegations that you allegedly shot at the direction of two people 2 days in a row. And you allegedly were talking out of your mind. Those are concerning allegations, Mr. Bell. But yes, you can ask for bond reduction, and what happens with that will be up to the judge that hears it, okay?
Yes, sir. I understand. Thank you, Your Honor.
Wish you the best, sir.
Yes, sir. Be blessed.
Tanya Henry. So Miss Henry, good morning. Miss Henry, you're here. I think you're being brought up just to make you aware of the U.S. Marshals hold. The question I have is everything I've got from the federal government says Tanya with two A's, Tanya. The jail sheet says Tanya. I believe your name is Tanya with two A's, correct?
Tanya, yes, sir.
So my question for the sergeant is the new arrests in Jackson County, are they under Tanya or Tanya? You know, Tanya. So the clerk's telling me it's Tanya. So hopefully the only thing that's wrong is the first appearance list. Hopefully the only thing that's wrong is the first appearance list, Sergeant, but I just want to try to make sure we get that cleared up. So you have a hold from the United States Marshal Service. I did take a look at that, Ms. Henry, because I wanted to see what the allegation was, and the only allegation they made against you is the new charges. So you're accused of the new charges, and that's resulted in them filing this affidavit against you. Ms. Henry, do you have any questions, ma'am?
No, sir.
All right, ma'am. Wish you the best. All right, so Mr. McDaniel, unless I missed somebody, that's everything we had on first appearance docket. Anything?
Okay, friends, it's a Tuesday. It's the Courtroom Files Live, and I am holding it together with duct tape and chicken wire today. The internet is messed up. I'm making a lot of changes on the fly here to try to keep the stream as good as I can for you guys, but I know that it's being buggy. So doing what I can to help you out. Let's change things up. Let's go to Tennessee. We'll spend a little time with Judge Wolf, see what's going on there.
You were placed on probation for a period of 8 years with the Community Corrections Program on or about September the 13th of 2024 for the offense of probation violations, with the original charges of evading arrest, convicted felon in possession of a weapon. It's alleged that you have violated your probation by violation of Rule 8, which states that you will refrain from the use of any intoxicants and so forth. And It alleges that you submitted a urine sample August 25th, 2025 to Aber Health that confirmed positive for THC on September the 4th, that you submitted a urine sample on September the 4th that was positive for alcohol. Those are the grounds for the violation of your probation or community corrections. I'll show that you have been arraigned. I will enter a plea of not guilty. We will set you for December the 16th for hearing. You need to make sure that you hire a lawyer and have that lawyer with you on that day, okay?
Okay, yes, sir.
Thank you. December the 16th. All right, at the jail, what is your name, please?
James Dubois.
Mr. Dubois is on page 1.
Wow. He's got several charges pending out of Dixon County. I believe though he has a suppression motion for those cases set in February. If we could just track this with those.
You want to set it for February VOP day?
Yes, Judge, because
All right, Mr. Dubois, you have apparently other pending cases and there are motions to be heard in those cases. And so your lawyer is asking to track those cases while setting your case for February 25th.
I go to court in Dixon February 27th.
So it's February 26th.
We can just give him the March.
All right, we'll put you on the March VOP day. March 31st. All right, thank you.
Oh my fucking God.
We have the State versus Curtis Day, which I show is on the docket today to set the motion for new trial. We're waiting on Mr. Atchison, is that correct? All right, as soon as he arrives, let me know. We'll try to take that up. 25 CR 19775, State versus Paul Dixon.
President, Your Honor, I believe this is just for an attorney status, and
It is.
but
He has a trial date set January 15th and expected to take 2 days to try. And then we have the last day to enter a plea would be January the 6th. So the trial judge has given you the January 6th date as your last date to try to dispose of the case.
Yes, Your Honor. I spoke with General Willoughby. I believe that Mr. Dixon was arraigned on September 9th. I had filed a request for discovery. General Willoughby's, we're working to try to get that discovery. There's been technical difficulties and different things that have occurred. The point of the matter is, Your Honor, I still don't have the discovery. And so I spoke with General Willoughby, and subject to your approval, we're asking that the plea date and the trial date be reset to March. So that gives me adequate time to receive and go.
I don't have a problem with that, but it's in front of that date that's set for trial is set in front of Judge Lockhart Mash. So I would suggest that you contact Judge Lockhart Mash's office and ask her to allow you to pass that to the March docket or to her next docket here. I'm certainly willing to let you put it in March, but I don't want to take it off of her docket. I don't think she would appreciate me continuing a case that's set for trial. So I would suggest you contact her office and see what she says.
I'll email her clerk today.
All right.
Thank you, Your Honor.
Thank you. He was only here today for attorney status, so Mr. Thompson, we show you as the lawyer. All right, at the jail now, what is your name, please?
Teague. Taylor Teague. Judge, I represent Mr. Teague being held elsewhere, stemming from new charges. I believe.
What page is he on?
Say it again, I'm sorry.
Page 4.
He's got some things going on in a different county, Judge. If we can set this to my next date in January.
In January. Taylor Teague. All right, January 27th for hearing. So. All right, Mr. Teague, your lawyer will be in touch with you and get you ready for your hearing. Thank you.
Thank you, Your Honor.
2024 CR 19559, State versus Shannon Elliott. I think this is only on the docket for, it's a post-conviction relief petition, and so we have to do an order, so we'll try to get that done in the next day or so. right, moving down the docket then. All right, at the jail, what is your name, please?
Chris Finch.
Judge, that'll be for hearing if Mr. Finch can just.
Mr. Finch, we're going to bring you over for a hearing, so we'll need to bring you into the courtroom. Thank you. Docket number 2025-019-710, State versus Jonathan Kane Krantz.
For Mr. France, today is his final plea day. He's got two separate cases. One is involving theft of property, 10 to 60,000, and the other is an aggravated domestic assault and violation of protective order. He has indicated to me this morning that he does not wish to take the offer, which the offer would be 2 consecutive A misdemeanors. The ag assault will be amended to regular assault, and then the order of protection violation will be ran consecutive. General Willoughby's offer to the D felony theft was an A misdemeanor theft running concurrent with the 2. Mr. Krantz is still deciding to decline that offer. And I know there's some suppressible issues in Mr. Willoughby's case, but we can set General Silver's for trial in March.
All right, today is your final day to try to resolve your case by an agreement, and it's my understanding that there's no agreement, so we will set up for trial in March. General Silver, you have, I think, specific days. Is that correct?
We could just do another status day and set it both. We can handle the suppression issue in March, and then the next time you be back on will be July. Maybe calendar will kind of clean up by then.
March looks pretty rough for me. July is the 2 count.
Okay.
I'm not upset with that. That wouldn't be bad.
So you want to just set it for status in March?
Yes.
On March the 10th?
And is there a motion day for the suppression hearing with the trailer?
Well, we have set motions on the 5th of March.
Okay.
So let's put it on the 5th of March.
Okay.
And I can tell you that probably whatever is on the 5th that doesn't get heard will roll probably to the 6th. So we'll go ahead and put as many as you need to on the 5th, and we'll go from there.
Yeah.
All right. Joe, what is your name, please?
There's Jonathan Gardner on page 2.
He's here on a violation of probation stemming from aggravated assault, I believe, or an aggravated trespassing out of Davidson County. He's got some pretty significant medical issues. I spoke with General Willoughby. Mr. Gardner is going to admit that he's in violation of his probation and be reinstated.
What Mr. Gardner needs to realize is this is the second time. They're kind of petty violations. I know the jail doesn't like accommodating his medical needs, but the next time is it. Strike 3.
Do you hear that, Gardner?
Say again.
Mr. Gardner, raise your right hand. Let me place you under oath. You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. You can put your hand down now. State your full name for the record.
Jonathan Eugene Gardner, Jr.
Mr. Gardner, you are here today on a probation violation. It's been indicated that you want to enter a plea of guilty to this charge and by the agreement of the state be reinstated to probation on time served. But do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand that you would have the right to have a lawyer and have one appointed, as I've done with a public defender?
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to that hearing, to that appeal. All I'm going to do is to find you guilty and reinstate you to probation on time served. Do you understand that?
Yes, sir.
Now, do you understand what the state is saying, that this time they really mean it when they say that you're going to go to jail if you violate your probation again? You understand that? They don't mean it. They don't mean just really. They mean it really seriously, that they're going to send you to jail.
Okay.
Do you understand that?
Yes, sir.
What I want you to understand is it doesn't matter whether the state says they want you to go to jail. The next time you appear in front of me on a probation violation, I'm going to send you to prison regardless of your medical conditions. And that medical condition is the only reason the state says that they're not seeking to have you incarcerated right now. Do you understand that?
Yes, sir.
Your last chance to prove that you can stay on probation despite your medical condition. And upon your plea of guilty, I find you guilty, order that you be revoked to serve your sentence, but by agreement with the state and based on your medical condition, we'll reinstate you to probation one last time. All right, thank you.
Thank you.
Okay, is it just me or was that super weird right there where he's like, the state really means at this time, like they double super secret mean it. It's kind of like the parent that counts to 3 before they punish the child, but the child knows that they can get to 2. I don't know. You tell me what you think in the chat. That just struck me as super odd. Let's change things up as we continue to hold this stream together with duct tape and chicken wire here on a Tuesday. The Cloudflare thing, by the way, appears to have been a cyber attack. So that's super cool. And that's why the internet is broken right now. Despite Cloudflare saying, oh, everything's up and running, but there's still ripple effects for sure. But let's change things up. Let's go to Louisiana.
Headquarters, we've already introduced ourselves, and you can see from our name tags who we are here. We're going to be handling a case at LCIW. The case is about Brenda Thornton, who is requesting to be paroled at this particular time. And so we'll go to LCIW. And Miss Brenda Thornton, would you introduce yourself and give us your DLC number?
Yes, sir. Brenda Thornton, number 121327.
Okay, thank you. And Warden, we appreciate you hosting us. Would you introduce your staff there that's with us?
Yes, sir. Kristen Thomas, Warden.
Captain Asha Harris, security.
And we have Miss Thornton's attorney with us in here.
Okay. All right. Where's Miss Thornton's attorney? Okay, there you are. Okay, would you introduce yourself, please?
Yes, good morning. My name is Hannah Rose Grodell. I'm Miss Brenda Thornton's attorney, and I'm with the Louisiana Parole Project.
Okay, thank you. We appreciate you being there and the work that y'all do. Warden, just as a note of information, I noticed the last time we were there, the camera is really out of focus. We can barely identify who's speaking. So you might look at that when you
Yes, sir.
We're offline sometime. We can conduct a hearing and that's fine, but you might check on that.
Okay.
Okay, Miss Brenda Thornton, today is going to be your day because you've requested this. We want to know what you did to get you there. We've got all the reports and everything, and we've all read those, all 3 of us, and I'll be doing the questioning later on. But we want to hear from you what you've done and what got you there, what you've done since you've been there, why you think you're deserving of an early release. And then we'll go to the warden and ask the warden exactly what all your conduct has been while you've been institutionalized. Then we'll move on to your supporters. I'll introduce them in a little bit. And then those in opposition, and we'll introduce those. So to begin with, Brenda, today is your day. Go ahead and tell us what got you there and why you think you're deserving of an early out.
Yes, sir. I would like to thank the board first and foremost for allowing me to be able the opportunity to speak today. I would also like to acknowledge that I did not speak as openly as I should have previously. I have always felt responsible for the death of Johnny Thornton, but now I understand the extent of my responsibility. Before I speak about my selfish and harmful choices, I would like to apologize to my son, John Derrick, and to the Smith family of Renee, Billy Wayne, Jason, Greg, and Alicia. No words can ever truly express my deep remorse and sorrow for the pain, the heartache, and the continued loss that I have caused you. I know your hearts are torn forever by Johnny's death, and I also know that you feel his loss daily, and especially and certainly on days like today. I truly regret the pain and the suffering that I have caused you by Johnny's death and my continued silence since then. I am here today because I am responsible for the death of Johnny Thornton. Johnny was suffering from a previous back injury that led to a recent hospital stay. Instead of working on our marriage, I selfishly and wrongfully began an extramarital affair that subjected Johnny to the anger, the jealousy, and threats of a very volatile and violent man that I invited into our lives. Dennis and I had had multiple conversations, and when he began to make threats against Johnny, though I did not agree, I did not notify the police or family members about the threats, though I had multiple opportunities to do so. When Dennis said he was coming over that night, I knew that he meant harm to Johnny, and even though my 3-year-old son was at home with me, again, I did not call or notify anyone for help. When Dennis hit Johnny with the bat, while John Derrick and I were in the house, I did not call for help again. My silence allowed Dennis to brutally murder Johnny and forced my son to witness the cruel and violent attack on his father. My choices forced my son to live a life of pain, fear, and suffering, and I am so very sorry that I caused him that devastating loss of his father and so much more. I did not stop the attack before or during it, and even though I knew Johnny was seriously injured, I did not call law enforcement, nor did I notify any family. I chose to make misleading phone calls and to destroy the evidence. I have not been forthcoming about my role in Johnny's murder until now, and I chose the weapon of silence and fear. Because of my silence, Johnny was brutally murdered, and John Derrick was forced to witness. There are no excuses for my failures. I failed to end the affair. I failed to stop Dennis from coming over. I failed to call law enforcement. I failed to notify my family. I failed as a wife, and I most certainly failed as a mother to keep my son safe. Because of my failures, Johnny lost his life, John Derrick lost his father, and the Smith family lost a brother, an uncle, and their loved one. Over the last 37 and a half years, I have confronted my failures and my shortcomings through a commitment of learning, of faith, and service to others. Through classes like Life Healing Choices and Thinking for a Change, I have addressed the selfish, fearful, and harmful actions of my past, and I have learned the tools needed to be a positive member of my community. In my roles as reentry court mentor and peer minister, I have been able to successfully implement those tools. I now understand that every word that is spoken or not spoken has consequences, and they influence those that are around me. I have learned to give and to not take. I have learned to heal and not harm, and I have learned to speak up when something is wrong, no matter the circumstances. I understand that there are no words, there's no actions, and there is no amount of change that can erase the painful loss that I have caused my son, John Derrick, the Smith family, other generations that follow. And this guilt, regret, and shame will be with me for the rest of my life. Today, I humbly ask the board to please grant my petition of parole to continue my decades of growth and service outside of prison. Thank you.
Okay, Thank you. Thank you for those words, and we'll get around to you and ask some questions in a little bit. We'd like to hear now from the warden. Would you tell us a little bit about her behavior and accomplishments and disciplines while she's been there?
Yes, sir. Ms. Thornton is one of our minimum security inmates. As she mentioned, she lives in one of our dorms mentoring. She has an excellent disciplinary record. Her last disciplinary write-up was in 2002. She's completed various programs, probably all of them. And she is an NOBTS graduate, which I know she's very proud of. And she does continue to mentor and offer peer support to the ladies that live here at LCIW. So like I said, we have zero issues with her. She's been a minimum security inmate for a long time. I know if she does get a favorable grant vote today, that she's working with the parole project for release plans and transition plans, which I know Mr. Blake will probably go into a little bit more detail on.
Okay. All right. Well, thank you for that. And we will, we'll go ahead now and talk to, let's go ahead before we get to the parole project and Miss Grable, is that what I'm saying? Am I saying that right?
Miss Grodell.
Grobel. Okay, Miss Grobel. Okay, I'll probably say it wrong in just a minute again, so I apologize. It's not intentional. We'll save you to last and let you wrap up at the end of the supporters. And so let's go ahead and talk to the DOC chaplain, Miss Deborah Sharkey. Is Miss Sharkey there? Oh, there you are. Okay. Yes, ma'am. Would you go ahead and tell us what you have to say then?
Yes, thank you. Can I stand here?
Yes, ma'am.
Well, good morning, and thank you for the opportunity to speak on behalf of Ms. Brenda Thornton. My name is Dr. Deborah Sharkey. I serve as the Director of Chaplaincy Services for the Louisiana Department of Public Safety and Corrections. And I also direct the NOBTS Seminary Extension Center at the Louisiana Correctional Institute for Women. Because of that role, I still return to LCIW regularly and stay closely connected to our peer ministers there. Before working at headquarters, I served as the chaplain at LCIW for more than 11 years. In total, I have known Brenda Thornton for over 15 years. When I first met Brenda, she was a student in our seminary program. She shared with me on numerous occasions that when she first entered prison, she was insecure, frightened, and selfish. But that is not the woman that I encountered. From the beginning, I saw someone who was quiet, patient, respectful, and steadily developing into a strong and confident leader. As a student, Brenda excelled academically and stood at the top of her class. I often watched her tutor and encourage women who struggled academically. She was never required to do that. She chose to do it because she genuinely cares about others and their success. After receiving her bachelor's degree, Brenda stepped up into key leadership roles. She became a peer minister, a reentry court mentor, and a trauma healing facilitator. In her role as a peer minister, Brenda conducts dorm rounds, performs memorial services, graveside services. Like the warden said, she has minimum custody status, so it's very few people that are able to go to the graveside to perform those services as inmates. And Brenda also facilitates CTRP classes. She does lay counseling and grief counseling. She strictly follows institutional policies and chapel procedures, particularly with confidentiality. Brenda consistently goes above and beyond what is required. She notices needs and takes initiative. She has excellent people skills and she is calm under stress, patient in conflict, and often serves as a peacemaker. Another role that Brenda served in was to go and to be an orderly when some of our women were incarcerated at LSP. That was a very trusted position as well, and one that was very difficult. And Brenda volunteered to do that. So I've watched Brenda help people in difficult moments, and After the flood, when Brenda was incarcerated at Hunt with some of our women, she stepped up and became the chapel liaison and the chapel support for every one of our programs, faith-based programs that was at Hunt. And again, she gave up a lot of nights of sleep and sacrificed a lot, was not paid to do that. And that was something that she volunteered to do because she felt a call to serve Christ by serving others. But even before Brenda became a peer minister, she faithfully served for many years in the chapel vestry, preparing for our services across multiple faith traditions, Catholic, Protestant, Episcopal, and Jewish. She coordinated our chapel events, both religious and non-religious. Because I continue to oversee the Seminary Extension Center at LCIW, I still see Brenda regularly. I've watched her continued growth, maturity, and stability. The woman she is today has been shaped by years of consistent, faithful service and personal transformation. In all the years I've known her, Brenda has demonstrated integrity, accountability, compassion, and leadership. And I thank you again for the opportunity to speak on her behalf today. I'm honored to do so.
Okay, thank you, Ms. Sharkey, for those words. We'll take them into consideration. Mr. Randy Clement.
Yep, got Clement. My name is Randy Clement. I'm a permanent deacon in the Catholic Church, and I was a volunteer chaplain at LCIW for many years. I am here to support Ms. Thornton's request for parole. This lady, Brenda, that I can see on the screen back of me, has been more of a minister to me than I was a minister to her. I have lost multiple family members in gun violence, including my uncle, a priest, my niece, and my nephew, a sheriff deputy, who was killed in a drug bust that went awry. I was upset and didn't even want to go back to the prison, knowing that I may go and help people that killed my uncle. But I went. And Brenda actually supported me and loved me through my anger times and showed me that there's another side of life. She helped me on my journey for forgiveness, where I got to meet the young man in the prison serving time for killing my nephew. I can truly say that I am a better person knowing her. I didn't know her at the time of this incident, all those years ago. I didn't even know she existed. I had never heard her story. But now I have had the pleasure of knowing her for the 25 years that I've been working at LCIW. And I can truly say that this woman will better serve our society if granted a parole, so that she can serve people in the public as she did with me and those in prison now. I'm kind of selfish though. I hate to see her leave LCI because she's such a valuable part of my life. She's been like a family to me. But in my opinion, it would be a huge loss to society for her to have to remain in prison. She is not the person she once was. I am here today to guarantee this board that Mrs. Thornton is going to be a remarkable lady and has helped us, a lot of us, including myself. I'm confident we will only continue to pour herself into helping others if she is granted release. Thanks for listening to me, and I'm honored to be to talk about it.
Thank you, sir. Thank you for those words, and we appreciate and we'll take those into consideration. Next, we'll go to Mr. Channing Blake with Louisiana Parole Project. Mr. Blake, would you tell us what you got on your mind?
Yes, sir. Good morning to this honorable board. Channing Blake with Louisiana Parole Project on behalf of Ms. Brenda Thornton. Because of the programming and the classes she's taken, she's been 20 plus years right up free. Her trustee status and her time served, we've accepted her into our program. We're going to offer her reentry services that include transitional housing, social norms, consumer skills, and many more. She will also be given a reentry specialist that'll mentor her through the reentry process. So based upon her record and rehabilitation, we ask that you grant her parole today. Thank you so much.
Okay, thank you, Mr. Blake. Appreciate that. And now we'll move on to Miss Hannah, Miss Grobel. Yeah, I don't know if I say that right.
We're gonna get there. My name's Hannah Rose. You can call me Hannah Rose. That might be easier.
Yes, ma'am. That might be.
I'm Hannah Rose.
Thank you, ma'am. Tell us what's on your mind, please.
Yes, first I want to start by expressing our deepest condolences to the family of Johnny Thornton. Their loss is immeasurable, and the pain that they have had to carry both over the last 38 years and in returning here today is profound. We honor their suffering, and we recognize the impact of this tragedy on everyone who loved Johnny. The fearful 24-year-old Brenda Thornton at the time of this senseless murder is not the same wise 63-year-old woman before you today. Miss Thornton now fully understands her role and responsibility and has spoken openly about her failures on the day Johnny died and her failures in the days and years surrounding it. What she did not share, out of humility and respect for the gravity of this hearing, is that she had been abused all her life until meeting Johnny. Her lived experience taught her that submission and silence were necessary for survival, and I do not offer this to excuse or justify her actions, but to provide context for understanding who young Brenda was all those years ago and how fear, trauma, and learned helplessness shaped her poor decision-making. While she neither committed an act of physical violence nor asked Dennis Moss to do so, Ms. Thornton has always felt deeply responsible for Johnny's death. She cooperated with law enforcement and accepted a plea agreement because she understood her failures and her choices contributed to his murder. Since that time, Ms. Thornton has spent nearly 38 years in prison, demonstrating an unwavering commitment to growth and service. For more than 3 decades, she has served as a Class A trustee, maintaining an exemplary disciplinary record without a single write-up in almost 25 years, reflecting far more than institutional compliance. This reflects genuine transformation. Ms. Thornton has become one of the most trusted and relied upon mentors within the institution. She teaches courses like trauma healing and thinking for a change, programs that are centered on emotional regulation, accountability, and healing. She also teaches good time classes, including Life of a Single Mom and the Onesimus Project. Since her last hearing, she's taken Sister's Keeper on domestic violence and Celebrate Recovery to continue her rehabilitation. As a reentry court mentor, peer minister, and lay counselor for the entire compound, she is entrusted with preparing other women for release, guiding them through crises, and modeling the self-discipline and morality needed for success. The institution depends on her to uphold the highest standard of conduct and to help others cultivate those same standards. Now, Ms. Thornton is a woman who knows and does better and is relied upon by the department to steer others in the right direction. Stephanie King, one of Ms. Thornton's supporters, who has successfully transitioned home from LCIW and now works in the Baton Rouge Public Defender's Office, wrote in her letter, "Brenda Thornton cares deeply about people and has no problem putting others before herself. When I first arrived at LCIW, she supported me and helped me navigate difficult times. I grew so close to her, I often called her mom." I am here to assure this board that Ms. Thornton presents no threat to public safety. She has long since aged out of any risk of reoffending. She has become a model of stability, integrity, and service. When this board recommended her for clemency in 2018, the warden remarked, "She is just focused on always helping others." And while no amount of rehabilitation can undo the harm of her past, the Brenda Thornton of today is prepared to re-enter society, not as the passive and immature young woman she once was, but as the humble, spiritually grounded elder, teacher, mentor, and servant she has spent decades becoming. We want to thank you for your time, your attention, and your thoughtful consideration of Ms. Thornton's request to complete the remainder of her sentence on parole.
Yes, ma'am. Thank you for those words, and we'll take them into consideration also for purposes of the record and so that Miss Brenda Thornton will know who all is here. Those that are here at headquarters but not speaking are Stephanie King, Beatrice Taylor, Susan Brown, Sabrina Monaco, probably wrong. Monaco, and Jan Waters. They are here in support, but not speaking, just so you will know that. We'll move on now to folks that are on Zoom, and this is those in opposition of this request. And we've got Brenda Renee Smith, John Smith, and Kimberly Hatton. So we'll first go to the victim's sister, Miss Brenda Smith. Miss Smith, are you on Zoom with us?
Yes, I'm on Zoom. Do you hear me?
Yes, we can.
Okay. I am in opposition. There is only half-truths that are told here today. And for that reason, I am in total opposition. For what she told, she made it sound like that Dennis Moss was totally in fault and she was only playing along but she totally planned out the murder of Johnny Thornton. She took out a large life insurance policy on him, and they planned his murder together. So she is totally at fault. And she did not tell that portion of the story. And I do not feel that she should be released. And she had a decision she could have made, and it come to that crossroad. And my brother is no longer here with us, and he cannot stand up for himself, so I am standing up for him. And I am totally against it and will always be against her release. And if my words have any bearing here today, I ask you, please do not release her and let the official court decision stand as it was on the day of the hearing back in 1988, as Judge Strong ruled in that decision.
Okay, thank you, ma'am. Thank you for those words, and we'll take those into consideration also. Let's move to those that are with Ms. Smith. Kimberly Hatton, if I'm saying that right.
You are.
Okay.
Thank you for allowing me to speak.
Yes, ma'am.
And I can't even fathom her wanting to get out. She held her 3-year-old on her hip. She watched. She had time. She knew Dennis Moss stopped in Faraday, Louisiana and bought the ball bat, the machete, whatever. This was planned. She's up there telling lies. Brenda, come clean. If you have done all of these deeds down there, that's where you need to be, because you're not telling these people the truth. You are not. God knows what you did. Yes.
Speak to the board, please, ma'am.
Yes.
Speak to the board and not her.
Oh, I'm sorry. Okay.
Yes.
Brenda planned it. She took out this big life insurance policy. She knew Dennis was going to stop and buy the ball bat, the machete. She stood there and watched them hit him over the head with it, stab him. She sat there and watched them drag him to his own truck and haul him off, and he was still alive when he was found. She then dug up the blood off of the ground and put it in a flower pot and covered the flower pot up with dirt to look like she planted flowers. She had all of this planned for money. And for Dennis Moss, for her boyfriend. Johnny had to drag himself, slide his feet to even go out there. And she told Dennis Moss that Johnny was trying to sell his welding truck or his whatever. She told him when to come and what to ask for. He was fixing to have back surgery. He slid his feet out to get out there to show him what he had for sale, and that's when they killed him. They stabbed him and hit him over the head with a ball bat. And she's going to sit down there and say that she didn't know. I mean, I cannot even imagine. She's lying to God. God knows what she did. Why would she want to uproot this child's life now? After he's gone on with his life, he's got a precious baby. He's got a precious wife. And why would you even want to come put that on him? He's gone on. Let him live his life. Don't come back and don't tell somebody that you will not try to enter his life again, because yes, you will. You've planned all of this. I'm proud of what you've done down there. I mean, it sounds like you've done what is expected of you or what you should do, but stay there. That's where you need to be. You have got a good life, obviously, there. Stay there. Don't uproot this child. Don't bring him. Don't mess up his life.
Miss Hatton,
I'm
please.
sorry. I'm sorry.
Yes, ma'am. We appreciate the comments, and we will keep consideration, take them also. Now, finally, on behalf of those in opposition, we'll talk to Mr. John Smith, who's the victim's son. Mr. Smith?
Sir, John Thornton Smith. I don't believe she needs to be released from prison. She just said everything to y'all. She knew exactly what was happening. She knew she had time to do something, to call the authorities, to stop it, but she didn't. She made that choice, and I was there the whole time. And you know, I don't think she should be released from prison. I really think she should be there, still stay there.
Okay.
And,
go ahead. I didn't mean to cut you off. Go ahead.
That's about all I got to say. I really don't think she needs to be released. That's how I feel. That's how I feel, sir. I don't think she needs to be released. She knew the whole thing.
Okay. All right. Thank you, Mr. Smith. We appreciate you coming on, and we'll take that into consideration also. I'm sorry to all three of you for your loss. I know you hurt a lot and continue to hurt. Okay, well, we'll move in now, Miss Brenda. We'll move in now to asking questions a little bit, and all three of us are very familiar with your case. We've read hundreds of pages of hearings and the trial and police reports and commutation of sentence. And it's up to me to ask the questions. Case was assigned to me. Your good time date is in 2036, correct? Is that the time?
Yes, sir, I believe so.
Okay, so you'll be released in July of 2036 if things go right because of the law. You pled guilty to first-degree murder and received a life sentence in 1988. Is that correct?
Yes, sir.
Okay, and then you came before not this board, but you came before the pardon board and asked them to commute your sentence to 99 years with immediate eligibility for parole. And that was signed by the governor in August of 2023. Is that correct?
Yes, sir.
Okay, and that's why we're here. We've heard the details of the crime, and I don't really need to go over a lot of that. It's apparent that, and correct me if I'm wrong, you knew exactly what was going to transpire and allowed it to transpire as planned. Is that correct?
Yes, sir.
Okay. I want you to know that all law enforcement and the victims, of course, you've heard the victim statements, but all law enforcement is very opposed for this particular effort of you to get your parole. I don't really have any other questions. I'm very familiar with the case and statements and victim opposition and from all of the chaplain testimony and parole project. So I don't really have any other questions.
I just got a couple, Mr. Prater.
Yes.
Brenda, where's your family? I mean, I see all these people here, but none of them say brother, sister, cousin, anything. I mean,
The majority of my family, Mr. Freeman, is deceased. They were older and in poor health. The few remaining people that I have, they are also in their upper 80s, late 70s and upper 80s, which is my mother's two sisters that are there. And one is out of state and the other one is in a dementia assisted living area.
did they ever come visit you? Were they on your visiting list at one time?
No, sir.
Okay. And tell me about this insurance policy. That one caught me off guard, and I was on your case before.
Yes,
So
sir.
did you purchase an insurance policy on him?
I did not take out the insurance policy. My husband took out the insurance policy, and there was no payments ever made on it.
Okay. That's the questions I had.
Did you encourage him to take it out?
No, sir. He did because he was going to be reassigned offshore. He worked offshore and he wanted his liability to increase in case something happened to him for his son and myself.
Okay, thank you.
Yes, sir.
I'd like to go into executive session.
Okay, we have a motion to go into executive session. Do we have a second? Okay, got a motion and a second to go into executive session. Hearing no opposition, we'll be in executive session. The time is 10:02. We'll be gone into executive session in the back room for just a couple of minutes. It won't take long. Then we'll come right back and we will take a vote and then announce our decision. So we've got some matters to discuss.
Okay, folks, we are a little bit in the Wayback Machine here, so I'm just going to bump us forward past the executive session, and then we'll see how all of this ends, hopefully.
Where you're
There we
doing,
go.
and I respect everything that everybody's said about you. However, because of victim opposition, because of law enforcement opposition, because of the fact that you do have a good time date, and hopefully we'll see you before then, but because of the fact that you pled and the family of the deceased, all of them thought that you were going to be in for life and then 99 years and now this. My vote is to deny your request. Mr. Freeman?
Okay, my vote would be to grant to the parole project for a minimum of 1 year, and that you not go back to the parish where this crime was committed. No contact with the victims or your son unless initiated by them. That's my vote.
I concur with Mr. Freeman.
Okay, I'm sorry to tell you, but the vote is 2-1. And I hope that you will take every advantage of applying again. But I think that at this particular time, you're doing a great job where you are. They can use you as a staff member. You're like an unpaid staff member, basically. And keep doing the same job that you're doing, and you'll be blessed beyond, and you'll bless other people. But this time, as I said before, your parole is denied. The time is 10:11, end of hearing.
Denied.
Okay, I was on board with the denied thing, but his comments at the end, like, you know, you're needed where you are, you're like an unpaid staff member. You know what that wording sounds like. So that was a poor way to phrase that, in my humble opinion. I'm not sure that that having heard that back, he wouldn't want to call back those words. But whatever. I got a few things I have to deal with outside of the stream here. We're going to go to Judge DeSanto. She's got a lot going on, so spend a few minutes with her. I may have to step away, but enjoy this, and if I do step away, I'll be back as quick as I can.
Was committed to not using.
Yeah, I would just like to say, like, I understand, like, you can check, and when I test, you can check the levels, and then if you have to test weekly, you can, or whatever it is. I'm going to stay clean for this 9 months, so,
Great.
but
I
I know
appreciate
you
your
can't.
permission for all of that, sir.
And no, you didn't need my permission. I just wanted to say that.
Okay, so the court's going to, note after hearing from counsel, hearing from Mr. Perlman, reviewing the report, the recommendation that the court does find there's reasonable grounds to depart from MCL 769.5. The court's also going to find that the following sentence in the best interest of justice is reasonable proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Torres and the legislative guidelines. The court's going to order 9 months probation. You're eligible for early discharge, which I'll go over shortly. You're also eligible under HIDA.
Okay.
That's because at the time of the offense, that you were 26. Despite the fact you've waited 7 years to take care of this matter, the law still allows you to be eligible under HIDA. You're not to violate any criminal law of any of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. Rehabilitative goal for that condition is so that the court can monitor your progress in maintaining abstinence and sobriety. The court's going to also order you to participate in the chemical awareness program. The rehabilitative goal for that condition is so that you can further educate yourself about drug and alcohol use so that you can make better informed decisions in the future, hopefully preventing this matter from happening again. And then the court's going to also order 5 days on the court workforce. The rehabilitative goal for that condition is so you can further develop life skills and get back to the community. The court's going to also order mandatory revocation of under advisement for any violation. Sir, this court has discretion to allow you to be eligible under HIDA. You waited 7 years to take care of this. If there's one violation, sir, then that's revoked.
I understand.
Any questions regarding those conditions?
Nothing that I can't ask the probation officer. I appreciate it.
Right.
Thank you.
$500 fine, $100 screening assessment fee, supervision oversight fee of $450. That's $50 a month at 9 months. And since you're eligible for early discharge, then up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce $200. That's $40 a day at 5 days. Chemical awareness program of $75, and there's a warrant fee. I believe it's $100. So
Okay.
that's a total of $17. Well, that's not right. It can't be 51. I get $17.50. Let me just double check that. It's $17.50 plus the $100 warrant fee for $18.50.
Okay. So after I pay that and do all the workforce and all the days necessary, that's when I'm eligible for early release.
I'm going to go over that with you. You're partially
Okay, I'm
correct.
sorry.
I'm going to go over that with you in just now.
Okay.
You do have the right, or you are eligible for early discharge as long as all the following have occurred. You complete at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Okay?
Okay, thank you.
Thank you. Have a good day.
You too.
Thank you.
Thank you, Judge.
And do we have Ally? We need Ally, right?
Oh. Okay.
Yep, we need Ally. Okay, Wayne County Jail, we're gonna do that, or Wyandotte Jail, we're gonna do that in just one moment. We just need to have Ally. In the meantime, we're on the record in the matter of the City of Wyandotte versus Terry Hernandez, 25608.
Good morning, Your Honor. Arthur Brand, P11126, appearing on behalf of the defendant who's seated to my left.
Okay, and Ms. Hernandez, your name for the record, please.
Terry Ann Hernandez.
Okay, today's the date scheduled for sentencing on your client's plea to an amended charge of disorderly conduct. The original charge of possession of controlled substance was dismissed by way of resolution between counsel. And there's also a bond violation hearing because it shows that your client missed drug testing on October 15th, 28th, and November 3rd, and tested positive on October 16th for cocaine.
I'm aware of that, Judge. Yeah. What do you want me to address first, the sentencing or
the bond violation? The bond violation, counsel.
Well, regarding the first violation, my client called me on the telephone and said she didn't have the money.
Counsel, is your client pleading guilty or not guilty to the bond violations?
Pleading guilty.
Okay, Ms. Hernandez, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And you just speak up, ma'am, because you're very muffled.
Yes, I do.
Okay, thank you. And ma'am, you heard the allegations regarding the bond violation, correct?
Yes, I did.
And you, as to those allegations, how do you plead?
I plead guilty.
You understand your rights as it relates to bond violation, correct?
Yes.
And you understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea.
I do, Your Honor.
And knowing all that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
And counsel, if you can please voir dire your client.
I didn't hear what you said, Judge.
Please voir dire your client.
Okay.
For the factual basis.
On the two dates in question where it is alleged that you failed to appear for urine testing, did those dates occur?
Yes.
And on the date in question when it's alleged that you failed a drug test, did that happen?
Yes, it did.
What drug was involved?
Cocaine.
And is it a fact that on that date you violated the order of the court by using cocaine?
Yes.
Thank you.
Counsel, there were 3 dates that your client failed to appear for drug testing, not just 2.
Oh, I'm sorry. 3 dates. Is that correct?
Correct.
All right. Thank you.
All right, the court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the bond violations. And counsel, what do you want the court to know regarding those bond violations?
Well, I have no excuse for what happened. I mean, you made it clear to my client, and she understands that she had to take those urine tests. I will tell the court that she had called me, I think it was before her first, I can't be sure of what date, before the first time that she failed to appear. She indicated to me that she didn't have the money, and I told her that I would loan her the money, I would give her the money. And so I'm surprised that there were other violations, to be honest with you. I know that my client is trying. Obviously, she's not trying as hard maybe as she should be trying. I would tell the court my client is in therapy at the guidance center at the present time. I'll tell the court that she has her only source of income is Social Security disability, for which she receives about $1,400 a month. I wanted to address what I thought was a very fair recommendation by the probation department.
Well, counsel, I'm sorry. Let's just hold off on that for just one moment.
Sure.
Is your client potentially interested in treatment court?
I do attend NA, Your Honor.
No, that's not what the judge is talking about. Are you interested in treatment court, which would be a program where you would be in a very intensive program to try to get you away from these problems that you obviously have with drugs? are you willing to go into a very intensive program is what the court is asking, where you would be monitored on a regular basis, and the court, not only you would be taking urine testing and other testing on a regular basis, but you would also be monitored by the court.
That's fine. I can stay at my home and take care of my dog.
What's she saying?
They're not asking me to stay somewhere,
I'm
right?
asking you, are you interested in going into such a program?
I'm
Just a plain old yes or no would be helpful.
yes.
Okay.
Okay, so then let's do this. We're not going to hold the sentencing today. I'm going to indicate that your client is interested in treatment court. It may be best for the drug court that's there in Lincoln Park. That may be the best fit for your client, but I'm not sure. In the meantime, so ma'am, you'll get information from probation as to contacting the 25th District Court Sobriety Court. In the meantime, the court's going to order 10 days jail on your bond violations. You are to report tonight. So you're going to have to contact probation as well to get that information about reporting.
Understood, Judge.
Could I speak?
My client
What do
wanted
you want the court to know, ma'am?
Your Honor, I have a home and a dog. I understand I made a mistake. I'm doing.
You made four mistakes, ma'am. You didn't go to testing 3 times, and then you used cocaine.
Your Honor,
That's in addition to the reason why you're here in the first place, but go ahead.
I have a dog at home. I have a responsibility of a home on my own. If there's any way that you could give me something other than jail, I have been doing community service at Trinity Church. I have been going to church on a regular basis. I realize I have a problem. I want to help myself. I'm not ignoring it, Your Honor. The times I didn't go, it's because I just didn't have the money. It's a hard life out there when you're a single person trying to live on $1,400 a month.
Ma'am, did you notify into probation? Did you email probation? Anybody?
I don't do email. I tried to call. You can't get through.
And that's why we tell people to email, because we have a lot more people calling than we do have staff members.
I don't do email. I don't even have a
In
computer.
fact, your attorney even offered to loan you the money. So, ma'am, you have until 6 o'clock tonight to report. You have somebody that you can find somebody to take care of your dog and lock your house up while you're in custody.
That's fine.
Don't say anything else.
Have a good day.
You too.
All right, let's go off the record for a moment here. Okay, Mr. Stemke, we have Ally in here now. Mr. Spellman. Attorney, is that Spellman? Mike Spellman for Discover Bank? I need you to unmute, I think. Okay.
Yes, thank you, Judge. Yes, Judge, Mike Spolman, P41216. And Judge, I'm of counsel for Buckles and Buckles today on the Discover Bank versus Timothy Rice matter.
Okay, all right. I'm just looking to see if Mr. Rice is present. I don't see that he is right now. So I have the in custodies I have to handle, and then I will proceed with some of the other matters that we have. Ms. Penzelis, I have not forgotten about you. I just have a couple other matters that I've had to.
Mr. Rice is in the lobby.
Oh, okay. Mr. Rice in the lobby, Mr. Spellman. So we're gonna he's gotta go in the breakout room. So we can, and that's him in the defense counsel one.
Okay.
Okay, Mr. Ewing?
Good morning. Yes, I am present. Sean
Good
Ewing on
morning.
behalf of
Why are you on Zoom? Mr. George is here in person. Did we indicate this is done on Zoom today or no?
my notice to appear dated September 29th states we are directed to appear at Zoom, and it has the court's Zoom information.
Okay. All right, so I'm gonna move, the person that's in the MIDC in the office, can you please unmute and turn on your camera? And Mr. Harkness, I understand that the defendants have not shown up on yours, so that will be pretty quick, but I have to do the in custody first.
No worries, Your Honor. I'm working on other stuff.
Okay. So, Mr. Spellman, I'm going to put you into breakout room 1, and as soon as Mr. Rice is logged in, I'll put him in there too.
Thank you, Judge. Then we'll report back shortly to the court.
All right, thank you. Is somebody out there helping Mr. Rice? You just let me know when you're ready, girls.
Yeah.
Oh, there he is. Okay. Do you have Mr. Rice in there, Mark?
Can you hear me now, Your Honor?
Yes. Do you have Mr. Rice in there?
Yep. I'm gonna put him on with his name right now.
Okay, very good. Thank you.
Okay, give me a second. I'll rename him.
I got it. Okay. So that's going to be breakout room 1.
Okay, Your Honor.
Yeah. She's good. I don't know where that. I don't know where that is. Oh. Huh.
Did 3 get closed out from earlier?
Well, I don't know where it's at that I put up. I just renamed. Yeah. Wait, I named him just as Rice.
Yes, I did.
Yeah. Oh, you did? Okay.
It's Timothy.
It's not showing up to where to join the, oh, hold on, that's why. Okay. There you go.
Thank you,
Okay.
Your Honor.
You're welcome.
Right.
All right, let's go on the record. In the matter of the state of Michigan versus Crystal Zamorsky, 251612, and the state of Michigan versus Crystal Zamorsky, 251614.
Good morning, Your Honor.
Okay, go ahead, counsel.
Do we have to do a reading first from the officer?
Oh, yeah, so I thought you were trying to put your appearance on the record. Okay, just good morning. All right, and so detective, your name for the record, please. Whoops, you're still muted.
Your Honor.
Okay, very good, thank you. All right, your name for the record, please.
Detective Joseph Carwine, Police Department.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
Your Honor, on November 15th, 2025, Officer Carpo was reported that she was dispatched to 1110 Sycamore Street regarding a larceny complaint. Officer Carpo reported that she arrived at the address and spoke with the victim, identified as a Dana Jakubiak. Officer Carpo reported that the victim stated that on 11:13, she noticed the gate located in the west side of her home to be unlocked and open, which was unusual. Officer Carpo reported that she checked her home security video and discovered that on 11:13, about 12:30 p.m., an unknown white female, later identified as the defendant, Crystal Zamorsky, is seen unlocking the gate and entering the yard and subsequently stealing items from a parked, unlocked travel trailer, which was located in the backyard. Officer Carpo reported that the victim showed her several home security videos where she observed and immediately identified the white female as the defendant from several prior police contacts. Officer Carpo reported the defendant is seen arriving at 1110 Sycamore with no shoes on and what appears to be a shorts or no pants. And a short time later is seen leaving via the same gate, wearing black boots and carrying a black bag, which was identified belonging to the victim. Officer Carpo reported she reviewed additional home video from the address which showed the defendant running in front of the home, wearing the black boots and carrying the bag. Officer Carpo reported that the victim had checked the backyard and camper area and discovered items stolen from the camper and damage to the garage. And, the items stolen include a pair of black hunter boots, a Nintendo gaming console, Amazon Fire Stick, and this gate locking mechanism. Officer Carpo reported that she checked the defendant's status in Lean SOS and discovered that she had an outstanding warrant on the 27th District Court for weapons offense. Officer Carpo and Kyle Cox arrived at the defendant's address located at 974 Eureka Road and made contact with her, where she was subsequently arrested on the local warrant and on the larceny. I spoke with the victim in the case the next day, and the reported items stolen appeared to be over $1,000, but less than $2,000, or excuse me, less than $20,000, and the damaged property appears to be over $1,000 and less than $20,000. And Your Honor, may I note that the defendant is also a second offense notice, which indicates that on October 10th, 2019, she was convicted of a felonious assault in the Third Circuit Court in Wayne County.
All right, thank you. Upon examination of the complaining witness, I find the offense charges were committed and that there's probable cause to believe the defendant committed those offenses. Counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemp, appearing on behalf of my clients. Time to consent to the matter being heard via Zoom.
Thank you. Ms. Zamorsky, your name for the record, please. Okay. And counsel, you're on the felony matter as well as on the assault and battery matter from November 13th. As to the arraignment on those matters, what are you requesting?
We waive formal reading. My client stands mute.
All right, the court will waive the formal reading. As to 251612, the court will enter plea of not guilty, schedule this matter for pretrial on November 25th. 1:45 p.m. And ma'am, you do have, as to the felony, you do have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. In fact, you've had the opportunity to speak to an attorney today, correct?
Yes.
All right, the court's also signed the petition order for appointing an attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right, the court's entering a plea of not guilty on your behalf on the felony matter, scheduling this matter for probable cause conference November 25th at 1:45. And as to bond counsel.
Your Honor, my client was gainfully employed. This arrest might jeopardize that. But that being said, she indicates she will come to any and all future court dates. She will comply with all provisions. I know financially she would have a difficult time coming up with a monetary amount, so we would ask consideration for any leniency this court could consider when determining an appropriate bond. Thank you, Your Honor.
Okay, so ma'am, you're currently on probation, right? Out of the Third Circuit Court because you failed to complete probation. There's a warrant for your arrest. Is that the issue?
What is that? I'm not on probation at no Third Circuit Court.
No?
No, ma'am.
Are you on probation in this court?
No, I did drug testing for you and I passed every drug test that you asked me to do. And on my jail review, I talked to the probation lady. I was currently in the hospital and I emailed you guys the paperwork. I called and I didn't get no return phone call regarding that. And I still have the paperwork. If you need that, I can get that.
What's that? Okay, hold on. Detective, what's the warrant that is pending for Ms. Zamorsky?
Your Honor, that is out of our 27th District Court. It looks like a weapons offense.
For jail review. And I was in hospital that day.
Okay, hold on, ma'am. Hold on. Can you pull that one out, please? That must be the one from April.
It's dated, issued on the 21st of October of 2025, Your Honor. So
Okay. Do you have that file?
I didn't hear, I was walking over here. She's on Joey.
I know. Right, I need the file. Can we get the file since she's already in custody?
And there's her note.
Is the fax date on April 5th?
Yes.
Yeah, it's in yours. She fills up here for the chair review October 20th.
I talked to Natalie Shaw and I let her know that I was gonna be in the hospital.
No, ma'am, you emailed October 24th. And you didn't submit any paperwork. And as far as the email goes that you're addressing. And so then you were notified you needed to either post bond. And if you post a bond, we'd recall the warrant, or you could walk in. You didn't do that.
I did email. I don't know if it didn't go through or not, but I guess I did do that.
You're not listening to what I said. You're not listening to what I said. Yes, you emailed October 23rd. And then I reviewed the email. You didn't attach any proof of being in the hospital. In fact, all you said on here was that you were sick. In fact, I'll read the email, ma'am. Yes, my name is Crystal Zamorsky. I had court the 20th. I've been very sick. I have told Marcy. She demanded the paperwork next day and told me, I don't know, or IDK, if you can reschedule my court date. I have to ask, she said, and that's wrong by law. You have to. I'm still very sick. And also some very, very serious things happened taking care of regarding my job with 2 or more employees that did identity fraud and had taken all my money. It's in the process of being handled. Also, the court needs to know my mother, Chris, calling police saying I hit her. That's a false report, but I had the police called that day to tell them everything going on. And I have got justice from not one officer. I'm tired of everyone lying and calling in on me with the most ridiculous things. Even I do biting, but sit at home until my mother kicked me out. Now I'm homeless. I want to know why I get cops coming to my house every single time a person calls or makes a lie up, any type of thing about me, period. They're at my door ready to put me in cough, period. Just like when I was, the rest of my mom lied and said I hit her. That's the other sentence, period. I was sleeping when I was arrested, period. There's no proof, nothing, period. I don't understand how that's fair, period. I'm being harassed by police and I want to have it stop, period. This is ridiculous and I'm tired of it. I'm to the point where I don't even want to be here anymore. I'm tired of everyone, family, the city accusing and treating me terrible. It's not fair. I want to have a call from the main person. I'm able, yell, speak to the judge personally. That'd be great. Can you guys please get a hold of me? Because last time I got there, nothing was ever mailed to me and no one ever returned my phone call, please and thank you, period. Have a good day. That is the email that you sent in October 23rd. The response to that, ma'am, was that you either needed to post a bond, and if you did post a bond, then we would recall the warrant, or you could walk in.
I apologize. I didn't get it.
Ma'am,
check my email.
stop. You sent an email. You should check your email. And you didn't do that. So don't try telling the court now that you were trying to come into court. So, because you just said that you were in the hospital. Didn't you say you were in the hospital? That's why you missed court?
Yes, I was.
Okay, not anywhere in this email does it say you're in the hospital. Your credibility is about nothing with this court, ma'am. You see that right there. Okay. And so, counsel, as to bond.
Your Honor, just any leniency this court to consider. I believe that my client obviously realizes that there are consequences. She's not appearing in court. She's experiencing them. So we just ask for anything which would potentially allow her to get out of custody, or at least a 10% cash surety provision.
I do have a job that I'm supposed to be checking up on that. It's at a dental office. I can't check it then at home at my phone. You know, I lost a lot. My car got totaled September, a day before my birthday, and my whole bank account got frauded. I'm trying. It's just, I don't know, man.
Ma'am, what I hear is a bunch of run-on sentences with a whole bunch of excuses that you think that are just coming into your head at the particular moment. That's what it sounds like to this court. You want to try to throw everything in to see if any of those excuses sticks. Where do you live, ma'am?
974 Eureka, Wyandotte.
Who lives there with you?
Just me and my mom.
Right. Well, your mom's the victim in the matter from just last week. So you won't be returning there, I can tell you that. So where else are you going to live then, ma'am?
I don't know.
What's that?
I don't know.
And who's the victim on the matter that you're currently on probation for?
What victim are you talking about, man?
The assault case in Wyandotte.
I'm sorry,
I don't know.
the jail,
I don't
the
know
jail review. Let me clarify, the jail review.
what assault you're talking about.
For the jail review case.
What does that mean? Oh, it's
The assault that I'm talking about, ma'am, it shows on November 13th.
Yeah.
You have a charge of assault and battery.
How am I charged with assault and battery when I was never arrested for it? I wasn't even home.
Well, ma'am, let me just say this. The police report indicates they were dispatched to the home in regards to a domestic assault. You left the location prior to the officers getting there. And so then they issued you a citation, ma'am. Or I'm sorry, they got you a citation. A warrant was signed for that.
Against who? My mother who was stage 4 lung cancer, dying? Why would I hit my mother? And I was not even home. How is that even illegal? How is that legal? I wasn't even home and I got issued an assault charge because me and my mother got in a fight and I left because I didn't want to argue with
I don't talk about the specifics of the case, miss.
it.
Where is it that you say that you're working? A dental office?
I have a dental office interview coming up this week, but I was working at Packray and I had 2 individuals bank fraud my account and I followed up with Ecorse Police and it's still going with that ongoing investigation. At Packray, I was working. They drained my whole bank account, my bank
Okay,
account.
so you don't have a job that you're working, you have an interview.
I was working last month, but I have an interview coming up this week. at a
With the dental
office.
office. Okay,
That's me.
okay. And so are you out on bond in any other jurisdiction?
No, ma'am.
Have you ever failed to appear in court for any reason
No, ma'am.
other than the jail review here?
No.
And
I promise you, ma'am, I'm trying to get my life together. Just I really, my family has been really.
I cannot understand what you're saying, ma'am.
Ma'am, I'm really trying to get my life together. My family and us been really under a lot since my dad committed suicide. I know what I've done. And I'm just asking if you're willing for me to get this opportunity to get this job and let me get my life back on track. I will not come to court.
Excuse me, who was the victim in the matter out of Livonia?
Livonia.
Yes, the stalking. Who was the victim in that matter?
That was my ex-girlfriend, and that wasn't even true.
Okay. Who was the victim? Who was the victim on the matter from Wyandotte that ended up being over at Third Circuit Court? Assault with a dangerous weapon you pled no contest to.
It was my brother. My brother lied against me in the police report. That's when my dad committed suicide.
And then who did the prior domestic violence you have, ma'am? Who's the victim in that matter? From 2018. Who was the
I
victim
don't
that
know.
time? Was it your mom?
No,
Who was it?
I'm not sure. I don't even remember recalling that.
Okay, given all the pending, the matters on your criminal history, the assaultive nature of your criminal history, the assaultive nature of 251612, and the matters that are pending currently on the 2015, I'm sorry, the 251614 matter with Ms. Jakubiak, the court has some serious concerns. Detective, would you like to address bond?
Your Honor, I do have some concerns about the proximity of the defendant's address and where the incident happened, the victim's address. So I would recommend a GPS tether. And obviously no contact with any victims or potential victims or witnesses in that case, in the felony case today. And I would also recommend a $25,000 10% cash bond, Your Honor.
All right, the court's going to note on 251612 for the reasons this court stated on the record, as well as the concern this court has for Ms. Zamorsky appearing in court and for the safety of the community, the court's going to order a $10,000 10% bond on 251612. On 251614, the court's ordering a $50,000 10% bond with the following bond conditions. You're not to have any contact with Dana Jakubiak or Gloria Zamorsky. That's phone contact, text message, email, social media, third party, anything of the like. You're not to return to the premises at 974 Eureka, nor 1110 Sycamore. You may return to Eureka, the Eureka Road address, one time accompanied by a police officer to pick up your personal belongings. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms or weapons. And you are not to be released without GPS tether through the Wayne County Jail. I'm sorry.
So what, my mom pressed charges on me? I can't even talk to my own mother?
Nope, sure cannot.
Thank you, Your
You
Honor.
cannot talk to your mom directly through a third party or otherwise. Not through writing, not through text message, nothing, no contact.
Thank you, Your Honor.
Thank you, Judge.
Thank you. And just for the record, on the 25443, the court's recalling the warrant and will set this GR review also for November 25th.
It's the Courtroom Files Live. It is Tuesday. It is a weird day today. She was weird. The courts are weird. As Michael pointed out in the chat, Judge Mom is sounding more like Judge Glazer today. Cats and dogs are suddenly living together in peace and harmony. I don't know. Odd day. But that's what makes it fun. I'm glad to have you all here with me. By the way, I do want to point something out. So, yesterday we put in the new Chiron, and there is the news scroll at the bottom. That news scroll, the links for every headline you see are now going to be posted daily over on our Discord server. There's a special section for it there. So yet another reason to join us on Discord if you haven't already, because if you see a news story that interests you as it's crawling by, you can easily go over there, click on the link, and do further reading and research on it. So another service we provide here at TCF. But seriously, I felt it was important to kind of give you guys a little bit of that content because we are a morning show, and morning is when news happens. So now we're more of a one-stop shop. All right, let's go to Texas. Judge West, say good day to her.
Okay. Good morning. Are you Khalil Bradley Harris? And let's see. It says it's locked. There it goes. Never mind. All right, sir. In cause number 25 DCCR 1334, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from August 10th of 2025. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? Yes, ma'am. And I'm assuming we've got the prior offense. So with regard to enhancements for trial purposes.
They haven't enhanced it, but they could.
So
and that's been a discussion.
Y'all have talked about this. So is there just the one prior felony?
Yes.
And is it a regular felony or?
Yes, it's a regular felony.
So I want to make sure you understand if you go to trial and you're found guilty, that because you have a prior felony conviction, it would enhance your punishment to that of a second degree felony, which means between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection here on the tablet that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 5 years, which means you would leave your punishment up to me. I couldn't give you more than 5 years. I could give you 5, I could give you less. It would depend on the information that was brought to me at a hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
I do also want to make sure you understand that after today, unless there's some new information that comes to light that your attorney or the state's attorney does not know, I will not accept this plea agreement after today. Do you understand? Okay, so we'll get it set for trial. Mr. Harris, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney to begin preparation for trial a little quicker. Is that okay with you? Well, it's up to you. Okay, well, Mr. Parker will remain on and begin preparation for trial then. All right, you can go back with the bailiff. Corey Balsamo.
Balsamo.
Corey Baltimore.
Mr. Paperwork.
Should be.
Yeah.
Oh.
Good morning. We're gonna have to get them printed first real quick.
Probably like, what? No. That wouldn't work. To your state jail.
Who's Erica here on? Erica Bursch. Okay. Are y'all ready on it? Okay. All right, sir, you are Corey Balsamo, or Balsamo. Will your client waive the formal reading of the motion?
Oh, Your Honor.
In clause number 20-34743, I have a motion to revoke your community supervision. Shows that you were placed on probation November 29th of 2021 for the offense of theft of service, a state jail felony. And that must have been enhanced because it was a 10-year sentence that was probated for 10 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to avoid places or persons of disreputable or harmful character, and that you were admitted using methamphetamines within the Abundance Living Facility with another resident. And is that true or not true? True or not true? Count 2 alleges that you provided a urine sample August 18th of 2025 that tested positive for methamphetamine. And is that true or not true?
Your Honor, state would waive counts 3 and 4.
All right, did you enter your pleas of true to counts 1 and?
There's 5.
Oh, I'm sorry, I didn't see.
We're waiving 3 and 4.
Gotcha.
Not 5.
Thank you. Count 5 alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
I see the problem.
Okay. It's a 10 over
10 over
10.
10, and it's,
He was enhanced and it was already convicted, so we can't do state jail.
I missed that, Judge. That's my mistake.
So I have to delete this paperwork because it would have to be TDC.
2 years TDC.
Y'all go, and it's, the paperwork's gone, we'll go back through this in a minute, all right. Let's see, Mr. Lewis, on Christian Montoya Lazo.
Yes, ma'am.
Ms. Burge. Good morning, ma'am. If you'll please raise your right hand, do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Yes, Judge. Thank you.
Okay.
And that's what he's being held on here in Harris County.
Yeah, he has a whole.
And an ice detainer.
Good morning. Are you Christian Lazo?
Yes.
And Mr. Lazo, in cause number 25, DCCR 1423, you're charged with aggravated robbery from May 25th of 2025. And Mr. Lewis, what is the announcement?
Judge, I've talked to Mr. Lazo briefly about the case, but there are some other issues he has out of county that he has holds for here. I got the name of the attorney over there. I was trying to see if we can get something worked out that would encompass both of them. I was under the impression he was setting trial on a robbery over there, but evidently it's something different.
Okay.
But I will check into that and make sure we get the thing.
Judge, according to his jail screen, he has holds from Harris County for a burglary charge and a theft charge. I looked on the Harris County District Clerk page. It only shows that burglary is pending at the moment. And it wasn't set for trial. It was just essentially a new case that he was not able to appear for because he's here. His offer is 25 years on this case. I would imagine if it's a burglary pending in Harris County, it's going to be lesser.
We'll take care of it first.
Yeah, and I think, Judge, honestly, in not being on the trial docket over there would make it a little bit easier for me to get with his attorney over there and get something worked out that will take care of both sides of it.
Okay.
I mean, of course, he has to deal with the access issue.
Okay. So I'll just do a normal reset that'll give you time to visit with the Harris County Attorney and Mr. Nichols, and then go out and visit with Mr. Lazo. And we'll see if we can get an announcement at the next court date.
Sure, Judge.
Thank you, Your Honor.
Thank you, Ms. Burge. Denzel Spikes, Mr. Lewis.
Judge, hold on, I know Mr. Howard was looking at that one.
Okay, I'll hold it.
All right, let's change it up. Let's head back to Louisiana, give that another try. They have a new contestant in front of them.
Okay, we'll continue the hearings from East Baton Rouge Parish Prison. Of course, we are at headquarters, Department of Corrections headquarters, and the lieutenant's already introduced himself, and I see him there, and I appreciate y'all hosting this. We're going to be talking to Melanie Bell. Miss Bell, is that you there?
Yes, sir. Good morning.
Okay, we're going to be talking to you about a revocation here, and the time is 10:43 in the morning. The date is the 18th of November of 2025. And your case, your particular case, the lead investigator interrogator is going to be Mr. Chuck Tillis to my left, so he'll take over here as soon as we do the preliminaries. Would you introduce yourself again and tell us what your DLC number is, please?
My name is Melanie Bell, DOC number 606934.
Yes, ma'am. And do you have a waiver in front of you, a piece of paper?
I do, sir.
And did you sign that?
I did, sir.
And that's your revocation hearing waiver, correct?
Yes, sir.
Okay. Mr. Tillis, would you take it?
Yes. Good morning. How are you, Ms. Bell?
I'm fine. How are you, sir?
You're in violation of rule number 4. On or about, my screen stopped. Okay. On or about 8/26/2025, you were engaged in criminal activity in the commission of a violation of protective order
This is evident by the affidavit for arrest warrant that was filed in Baton Rouge at the Baton Rouge Police Department under number 25-01877. You were arrested on 9/5/2025 by the Baton Rouge Police Department due to the arrest warrant. On or about 9/8/2025, you are able to bond out of jail with a notice of probation and parole for being in violation of supervision. Thus, at the time, the parole warrant was filed and issued on 9/16/2025. You were subsequently remained in court on a said parole warrant on 9/30/2025. This listed offense is pending in the 19th Judiciary under docket J25-0006497 on 10/8/2025. The District Attorney's Office billed Ms. Bell under docket DC 25-04726 for violation of protective order classified as misdemeanor. The matter remains pending in the 19th judiciary status. How do you plead to that, guilty or not guilty?
Not guilty, sir.
With the statement?
Yes, sir. The incident that is reflected in that document, there's no other way to say it simply didn't happen. I did not violate the protective order. The person I have the protective order, well, that has it against me, our children go to the same school. I did see her on that date, but no words were exchanged. Nothing happened. I picked my daughter up from school and I took her home. I believe I have family there that is willing to speak on my behalf. They were with me on the date of this incident. It was an open house at the school, and I went there. I met my daughter's teacher. I left with my family. I was there with my older daughter, my child's father, and my father. I did not have any interaction with that person, and I'm not sure why she would have a police report drawn up for that. But I wasn't even arrested on that date. I was remanded at court when I was being taken off probation. The judge for my probation decided not to even hold me because he didn't think that the validity of the complaint was valid. But that just didn't happen, sir.
Did you take any pictures of her or that?
I did not take any pictures. I had no interaction with her whatsoever.
Okay, you didn't put them on FaceTime or anything?
No, sir.
Okay. We have with us today, speaking in your behalf, is Mr. Clifton Bells, your father, your dad. Mr. Bells, would you like to go before the podium and tell us?
Yes, I was.
Would you stand behind the podium and tell us what you want us to know?
Yes, I am Clifton Bell, the father of Melanie Bell, and I was present at that school meeting. And as a matter of fact, my granddaughter and my other granddaughter's dad was there. And we went to open house at the school. And as we left out of there, I didn't even see her. I didn't see Miss Jones or whatever it is. And we left out there and left out the parking lot. And I think Melanie told me she did see her there, but that was all. I didn't witness nothing. And I told her, I talked to her. Melanie is, presently helping me. Like I said, I'm an elderly gentleman. I'm sick. I lost my wife in April last year, and I'm raising two girls. These two, right? This one and one that's 9 years old. We were all at the school over there. Nothing transpired. And I know the people over there. I could have probably went over there and talked to them and maybe got something from them and asked them why this happened. Because, nothing happened there at the school. And I don't know how this came about. I was shocked too because I brought her up here for the probationary hearing. And when she went upstairs, I was sitting out in the car because it was supposed to walk in and walk out because she's been to every avenue that was designed for when she came out of probation. She went to school. She went to a drug school. and she went to something else, trying to get straight, because she had to raise these two girls. I'm sick. And, like I said, learning how to be a housewife by myself with two girls washing and taking care of it, and she's home with me, helping me. And this is, I mean, this is ridiculous what this girl did. Again, like I said, it did not happen, and I did not witness that. I know of her.
Thank you. Thank you, sir. We appreciate your statement. Kevin Levy,
Yes, sir.
you want to speak now?
Yeah. It's Kevin Levy, and I was there also at the school open house. We sat there, we met the teacher and everything. I did see Miss Jones pass by the classroom. They did not. I didn't say it. Once we got out the classroom, they were down the way. They looked, we looked, we went the other way, we left. Melanie left with her father and her daughter. My daughter came with me to go play. We both went our separate ways. I've seen no altercation, no words were exchanged, nothing happened of that nature.
Thank you so much.
Wait, I got a question. Did you see the pictures on Facebook? Were there any pictures on Facebook to your knowledge?
Instagram.
Instagram.
Okay, no pictures.
Instagram's the one that goes away. Huh?
No, Snapchat.
Okay, thank you.
Any other questions?
Yes, sir. No, not of him. I do of her.
Yeah.
Okay, I've got a couple of questions. One, I was reading the affidavit for the arrest warrant, and the Baton Rouge police officer says that she, after reviewing the details of the investigation, which included the officer's report, the victim's statement, and reviewing the evidence provided which showed the defendant, that's you, on the school campus, as well as pictures of the victim and her daughters posted on your social media Instagram account. It's believed probable cause exists. The officer saw some pictures, the pictures of the quote victim and her daughters on your Instagram account.
That's not possible. I've been logged out of my Instagram account. These people, I have a history with. When I was incarcerated last year, they had my cell phone. They actually stole a ton of my stuff, and this is where this stemmed from, sir. So I haven't had access to my Instagram or my Facebook since last year. I actually created an entirely new one. So there couldn't have been any post that was made from my Instagram account or my Facebook because I'm locked out of them. I can't get into them. I have a new Facebook account and I haven't even created a new Instagram account. So that couldn't have possibly happened. There's no possible way. And when they issued this warrant, my address is on the protective order. No police officer was dispatched to my house to arrest me. No one came to question me. I was remanded at court. The first time I was remanded at court was when they told me there was an arrest warrant. I sat for 3 hours until they actually got the warrant and put me in jail. I was able to bond out on that. And when I went back to court on the 30th, that's when they arrested me again for a violation of my parole. So I had no idea that there was nothing to post on Instagram or Facebook. I had no interaction with these people. I did see her, but when we saw her, we left. We actually left the open house early. I left with my dad, my baby's father, and my daughter. I had zero interaction with this woman, and I have no idea why they continue to try and deflect on my character or try to keep me in jail. But the only thing that I can think of is because they stole my furniture and they want to keep me in jail. I have a civil suit against these people, and we were supposed to go to court on November 17th. They deferred that till January 16th. and I'm supposed to go to this civil suit with them. The protective order, the judge ordered, it ends on December 14th. It was issued in June for 6 months.
Okay. And what was the outcome of violating protective order?
They actually have affidavits from 2 of the secretaries at the school stating that there was no altercation. As far as my lawyer has told me, on December 3rd, when I go to the hearing for this, those charges are going to be dismissed for violating the protective order, but we won't know until we go on December 3rd.
Okay. And tell me about the Grove. That's in our report here, that you were discharged from the Grove Recovery Center. Tell me about.
When I originally got out of jail, I was on a treatment bond. I went to the Grove and did 28 days in their residential treatment program. And then I did 3 months of IOP. I completed that. And 2 days after I completed IOP, I was arrested again. But I completed the entire treatment recovery program at the Grove.
Okay. And are you using any kind of substance now or?
No, and I've been drug tested faithfully. I've been drug tested every week by the Grove up until the week that I went to jail, and I passed all drug tests clean, and I'm clean of any substances right now, sir.
Well, congratulations. I hope you maintain that particular record.
I plan to, sir. I have 2 young children. My dad's 77 years old, and he's been, after losing my mom last year, he's been raising my 2 girls. My 9-year-old got on the phone with me yesterday and she told me, she wants me to come home. And, she said, every time I tell her that I'm coming home, it's longer and longer that I don't come home. But I'm explaining to you, sir, I had no interaction with this woman. I did not violate that protective order. I wouldn't do that to my children, and I wouldn't risk my freedom.
Okay.
I'm ready to vote.
Steve,
I'm sorry.
No, I mean, I was trying to look through all the reports. There is no pictures, and I think there should have been some pictures in our file if she posted that. There definitely should have been some pictures in our file if they were posted.
Yeah. My vote is to do not revoke.
My vote is to do not revoke, but I'm gonna reiterate, as a condition of your parole, you stay away from this lady until you're off supervision.
I will.
And you gotta go to school. Understand?
I'm gonna pull my daughter out of that school. There's another school like in our neighborhood that she can go to. I'm gonna enroll her in that school so that I don't have any.
Okay, well, I'm just telling you, don't have any contact with her. Do what you say. If you see her, turn around and walk away. Just wait to vote. Okay, so I also vote do not revoke.
Okay. You got 2 votes to do not revoke, and that's all it takes. So you're not going to be revoked. And mine would be also do not revoke. But if in December you're found guilty of having violated this order, I'd like it to come back up before us.
It can't. We would have to continue it. You'd have to continue it now to wait for that. Because we already got the violations charged.
Sir, I'm pretty sure.
Hold up, please.
Okay, all right. We got 2 votes to do not revoke, and I will concur with their decision, and I would like to be notified. I'll ask probation and parole to notify me about the results of this particular hearing. So as of today at 10:58, you are not revoked. Yeah, and so we'll sign the proper paperwork and all of that. Continue to, I encourage you and we'll pray that you continue to be off of any kind of substance and stay away from these folks. They're going to try to catch you tripping up. And so stay away from them, but you know that already without me having to tell you. So as of today, your parole has not been revoked at 10:59. Thank you. Thank you, East Baton Rouge. I think that's all we got with you.
Approved? Weird. Cool, but weird. All right, let's go back to Judge West. Let's make that happen.
Morning, sir. You're Brandon Bell. And this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true and a motion to revoke deferred probation. Pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
I have, Your Honor, in addition to some medical documentation that Mr. Burbank has provided.
Was that provided to me?
Not,
Okay. I'm sorry.
probably not.
Okay. Is it, what should it have, do I,
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
uh-huh. I don't know what you're talking about. Yeah, I mean,
These are medical records from Spindletop.
okay,
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working,
okay,
which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you were called the complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know
Okay.
that's been a concern, but I had some difficulty with that portion of the case.
okay,
And if the court would also remember, she was expecting another child, they are expecting another child. And
okay.
she's
So what,
also-
I get, go ahead and make argument and then I'll,
She's also controlling the checking account. He's getting settlements and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, I have some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there's some program that he can have that's outpatient, to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to the pre-sentence report, he is reporting. It's not like he's not reporting. He's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not he can do it. And you couple all that, I've had extensive conversations with his wife I've tried to tell her the way it has to be, as of yesterday. We've talked over the phone, in the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8, Ms. Lopez?
I mean, I guess it kind of depends on
Just in the context of what she has to say.
Yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair?
Yes.
Affirmative, record reflect. Ms. Lopez is identified as the defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition. Can you explain that to us?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called. And so it's standard in our court orders that they are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation, etc.
Yes, we need updated phone numbers, addresses, things like that, so that we can specifically talk to the defendant.
And he pled true to additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like spindle top, yes, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that that may be a recent thing, and so that may not be applicable yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include in the motion.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the office visit that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which lends to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type. And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated synthetic marijuana use.
And that information is also reflected in your update to the court, correct?
Correct.
With respect to how his behavior appeared to be altered, involving odd hours, showing up at odd places, attempting to contact the complainant, etc., regardless of whether or not they mutually agreed to do so. And I believe your recommendation is very well thought out and very well put in the updated PSI. Do you have anything to add to the report?
I do not at this time.
You have some questions.
I have some questions. Mr.
Yes, sir.
Ma'am, did you ever get his records from Springfield?
I believe so, yes.
And is he under medication?
Not during the time of all of this taking place. I know that since he was out on bond, I believe he went to Spindletop as of August 11th, and that was when he began having his medication the way he was supposed to.
In your report, you stated in the first or second paragraph that while the defendant does report as directed, he has made basic efforts towards paying his fees, correct? So he has been reporting to you.
Correct.
And then you also started receiving phone calls from the victim. Did you have any dealings with the victim at all? Were you here the last court hearing?
I was.
She didn't act very rational either, did she?
Not often, no.
And do you realize that they are expecting another child?
Yes.
And how many other children do you remember?
I believe they currently have 3 children together. I believe this is the 4th.
If I told you that there was a settlement to Scott Brown in reference to the motor vehicle accident that took his leg, you wouldn't disagree with that?
He told me that at the jail when I did my PSI update.
And he's getting monthly, I guess, settlement checks or quarterly settlement checks, in which the wife does have access to his account.
That I don't have any knowledge of.
You did also receive telephone calls from his mom, correct?
Correct.
And basically, she said that he's talking out of his head, he has mental health issues, right?
She did at one time, yes.
She didn't know, well, has to be between April and now, right?
Yes.
Because he was put on.
Specifically whenever he was out on bond.
Okay. He did appear or direct to be kind of delusional state, correct?
Yes.
Unable to remember reference to taking medications or injecting, so he was on some type of medication, correct?
Correct.
And that one of his problems is that he has to learn how to remain on his medications in order, from Spindletop, in order to, I guess, try to live life normally, correct?
Correct.
Nothing further.
Anything else, Ms. Buffino? I don't know yet what I'm gonna do, but if, is there any reason based on the injury that Mr. Bell could not go to special needs safety? Is that something that would prevent him from going?
I do not believe so.
You don't think so? You don't think so?
I think there are people that have gone to Spindletop that are
Sure.
in wheelchairs and things of that nature.
Yeah.
I said Spindletop, I'm sorry, Safety.
Yeah.
So I think he would still be able to go. I think it would be under special needs.
Right, that's what I would,
Yeah.
if that were an option, it would be special needs, because that would address
But
both
that
of the.
addresses mental health also, Jeff.
Yeah, that's what it's for. I mean, and here's the thing. I think a lot of the mental health is because you're using synthetic marijuana. I mean, that's gonna, so.
Judge, I think you have a lot of information before you end your decision. I do think it important, and I didn't want to hide behind the fact that we have had the issues with the complainant that she did come and testify.
And that's the only thing that's keeping me from doing probably what needs to happen.
But I don't have an interim update with respect to her.
Have you heard anything?
I have not heard anything since all of this happened. The reality is she's called me multiple times and complained and said that Brandon's here and she wants him gone. But Ms. Lopez, please don't send him to jail. She is very back and forth about it. My largest concern, Your Honor, is that the offense that the defendant is on probation for is extreme. And my biggest issue, in truth, is the fact that Mr. Bell does not take any responsibility for any of it. at all.
I don't disagree.
Can I just have one question, Jason? Did his accident happen after,
When did your accident happen?
November 4th of last year? Of last year.
So all this has happened since he's been
No,
on
but was
probation.
this
Prior.
before- was that
His
prior to
accident
his
was
accident?
prior to when he was placed on probation.
Right.
No, but how about the incident itself?
Oh, the underlying offense?
Yeah.
April of last year. So the underlying offense was prior
Prior to him.
to
losing
the
his
injury, but the injury was prior to probation where he's still, I mean, regardless of the, you can still do things to injure someone, to harass someone, to put someone in fear with or without a leg. And that's what he's done. That's what you've done. Still make babies with her. I mean, I don't know. I mean, that she was pregnant. The whole point of this is you beat the crap out of her when she was pregnant, and now,
Third child.
and now we've got the fourth.
Correct.
Would you like me to do a bailiff's call for her and see if for some reason she showed up today?
Sure.
Or needs to speak with her, Adriana Bell?
Can we do a call for,
Adriana Bell?
I don't know if that's gonna help either, though. We've done that before.
And I don't know if it's a situation where it's the court needs to protect somebody from himself.
That's-
Do you want to reset it so I can?
I don't think it's gonna matter. I mean, she's been here before. I've ordered,
No response, right?
I think I have her mother's here.
but they had there was a no contact, and now we have another baby. So obviously there was contact.
Can I just, from what I found out, Judge?
I don't need Snickers from the gallery.
I'm not calling them as witnesses. Every time they got mad at each other is when she got on the phone.
But she got on the phone, but that's him blaming. He beat her. You admitted to beating her. So she's probably scared when he gets mad. And then it gets okay, and then it gets mad. And he doesn't know how to get mad without beating the crap out of her.
I didn't get that indication, Judge. She's been to my office every other day. She's called. I mean, it's really,
I'm not in disagreement that Ms. Bell is also the problem, but my biggest concern here is their children.
separation.
Yeah,
I don't care if they stay together or not, admittedly, frankly.
Yeah.
I'm more concerned about the children involved in this case because of the violence that they're being subjected to. Whether or not the two of these adults can reconcile is between them, but there are children involved that I am extremely concerned about.
I agree. All right, here's what I'm gonna do. Mr. Bell, I don't feel like I have any other choice at this point but to protect your children and to protect your, I don't know if y'all are married, girlfriend, wife, mother of your children from you. I understand the mental health issues. From what I can tell, most of those are self-induced because you were using K2.
There haven't been an incident since I've been on probation.
That's not true.
I haven't had no abuse case since I've been on probation.
Okay, so you haven't abused her, but you weren't even supposed to be around her. I gave you don't talk over me, because y'all I told you when I put you on probation that she cannot give you permission to violate my order.
Yes, ma'am.
She can't say, it's okay, come on over.
She came to my house. I was staying in the house. She wasn't staying there.
Lock the door, kick her out. You're the one that's gonna go to prison.
She said that she called the laws to kick me out, and you said it still was an issue. She called the laws to kick me out. My mama came and got me. And I've been staying with my mama. I ain't been around her. She been calling the laws on me every time she come to my house. I paid $100,000 cash.
Why are you still having sex with her and having babies?
That's early on.
Early on when? We've only been doing this for 6 months. You've had 6 months, and all this has happened in 6 months on probation.
It happened 3 months because she finna have a baby next week. 3 months before I was on probation.
So what if she shows up at your mom's house?
She not gonna show up over there. She know her and my mama don't get along.
Probably for good reason.
I would represent to the court that there is a problem there, Judge, because even when we talked about possibly with him seeing the kids without her at mom's, and that wasn't a possibility. It's something between her and the mom, his mom. And I know his mom, his brother has gotten in trouble. She has a very stable job at a bank. She's very straight-laced. His brother was the one in the West End that was burglarizing cars, and the owner stopped him and shot him about 8 times on the road and left him there. But she is very straight-laced, and she just couldn't get off of work this morning because of the bank.
So,
But he needs something, Judge. I mean,
well, but we tried to give it to him.
well, I'm talking about.
I have money now to pay for my battery class too. I have money to pay for my battery class and pay off my probation.
I'm not as worried about you paying off things as I am you having continued contact with her.
I'm not gonna be in contact with her anymore.
Is there a way, Judge, to put him on a GPS and reset this for 60 days?
No, I'm going to make my decision today because I'm absolutely, if I leave him on probation, he's going to safety, period. So we're not going to get out and see how we do and take that chance without having some kind of treatment up front. I don't know. Y'all hold on a second. Just don't take them far. For some reason, Anna, when I pull up the version that should have my notes on it, it doesn't have anything on it.
Okay, friends, unfortunately, I'm in a position where I have to call it a day, but what I'm going to do is I'm going to keep an eye on this, and we'll probably post a separate video or at least follow up with it tomorrow so we know what her final ruling is. But I can't stick while she figures it out, unfortunately, today. Thank you all for joining. This has been a heck of a day with the tech issues, with the problems at Cloudflare and everything else. This is probably the hardest I've ever worked to hold a stream together because it kept wanting to break, and somehow I kept it from breaking. So I hope it came across okay, and I hope it was a good show. Appreciate all of you. We'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, where we're going to talk about juveniles in court. When they're tried as adults, are they tried too young as adults? Is it just right? So we'll discuss all of that. And we'll be back tomorrow, obviously, for the morning show, 10 a.m. Eastern, 7 a.m. Pacific, 45 minutes early for channel members. Please do like, subscribe, share the show with your friends, subscribe to our Discord in the pinned chat, all of that stuff. Help us out, and hope to see you again tomorrow. It's been a weird day. Try to find a way to make it a little better for yourself. Make it the best day you can. We'll see you tomorrow. Take care. God bless.